All right. All right. I made it. I made it finally. So, day 21 and Vince was first. He beat me. Um yeah. I thought I was being overly conservative setting it for 1:30 my time today, but apparently not. I was still a little too ambitious, but there you are. Linz, I will see you, well, you'll see me later. So thanks for stopping by to say hello. We'll miss you in the chat, but real life takes precedent. So yeah. And Paul, yeah. I mean, obviously, I haven't seen Action Jackson's Little Alan Jackson's Cross of Trooper Buchanan yet, but I have a feeling his questions are going to be even more incomprehensible than Yanetti's were yesterday. And as you saw, Yanetti's cross examination of the lab geek drove me nuts because they weren't English. I mean, I'm good at not Englishing, but he was terrible at it. Well, he was great at it, but terrible at Englishing. So that's it. It's the Russian nesting doll of double negatives and non-pull, I guess that would be negatives. And Nima, hello. Good to see you again. I think this is the second day I've seen you in here. Maybe. Either way, welcome. So, as I give my little pre-court ramble, I continue to be amazed. And the free Karen Reed crowd still continues to amaze me, I should say. And Kevin, I am really appreciative of that fact. Well, both of those facts. Looking at it, today's Law and Crime feed is 3 hours and 3.5 minutes. And I had to scroll through just under 20 minutes of that to get to the start of court. So it's actually a real short court day today, which makes me happy because boy, yesterday was long. I'm still feeling it. I'm still feeling it from yesterday. Oh, and JT Davis, I have a feeling he is the prairie dog, and I think that's an insult to prairie dogs. Kova, you're not late today, so hopefully that means you got a notification and when you didn't yesterday and all that. But yeah, so the free Karen Reed crowd continues to amaze me. To me, once again, as I've said, I am not a fan of Karen Reed, but I'm not letting that cloud my judgment, and neither is Dante. Hello. I'm letting the evidence speak for itself. And I'm judging it based on, how it's presented, the credibility of the witnesses, yada, yada. And yesterday, to me, was devastating to the defense. We had the video of the ring cam that we think was deleted, in Karen Reed's drive-by, after the hospital, her and her father's, blitzkrieg of the O'Keefe residence, grab stuff, get on the computer, and bolt. But the subpoenaed ring camera video from 5:07, when Karen was leaving to drive to the McCabe residence to look for Johnny, and it didn't look like she struck John's vehicle. There was absolutely no evidence of taillight fragments on top of the snow on the O'Keefe driveway. And as she was pulling out, it was clear to me, at least, that the taillight was broken. Now, the Free Karen Reed crowd, at this point, I think nothing is going to change their mind. And I haven't watched his video on it, nor will I. But Uncivil Law, an attorney, he's a member of the Bar of Virginia and Texas, maybe one or two others. Of course, he's a patent attorney with a love for constitutional law. And in the Free Karen Reed crowd, I can't remember if it's the title of his video or the thumbnail, but it said, lying trooper gaslights jury that red taillight is actually white. And either he wasn't paying attention or the facts don't matter. Because here's the problem. So, yes, there was still red in that video. No dispute that there was still red in the passenger side taillight. I mean, we've seen the photos of the taillight housing as it was when they seized the car. There was still, a third of the red lens still in the housing, with 2/3 missing. So you are going to have some red illumination. The problem is, for Karen Reed, there was white, clear illumination in places that should have been red. So there was still red, but there was more white than there should have been. Full spectrum, white light, clear light, And where that was most evident was on the passenger side, because remember, the taillight wraps around. It's on the rear and wraps around onto the passenger side. And the jury can see this because they've seen the Puzzle Masters reassembled taillight. But what happened is there was white light on the side of the vehicle, not just the rear. And the reason that's a problem is on the side, it should only be illuminated red. During the stream yesterday, to make sure, I looked up pictures of a 2021 LX 570. Solid red on the side, no white. White is only the reverse light on the rear. So if it's illuminating on the right on the passenger side, that means it's broken. And that's what I saw. There was still red. There was still red at the top of the side, but there was white where there shouldn't have been. And the thing is, the reverse light, is only on the back. Should only be on the back. And the yeah, it's a problem. It's a problem for Karen Reed. It's a problem that, like I said, I think some people are being willfully blind to that fact. But hopefully the jury sees it. And, like I said, I haven't seen little Alan Jackson do any cross examination yet of Trooper Buchanan. But, I can see him asking, isn't it true that there's red illuminated on here? And Trooper Buchanan, should respond, but there's also white where it shouldn't be. And, hopefully clears that up. But it got worse for Karen also because, well, number one, well, back up. Reverse lights on, back up. So part of the defense, blitz before the trial was, well, yeah, it was broken, but it was broken at the O'Keefe residence. It was broken at 5, not at midnight. But since there were no taillight fragments, now they have to change the story and say, well, it wasn't even broken then. Because I think the story before was, well, yeah, it's broken as she's pulling out of the driveway, but that's because she just broke it. And now they have to change the story. They have to change the narrative. And I'm hoping that today, because Trooper Buchanan is still on direct, and I'm hoping we see the city's motion activated camera, and because remember, the last witness on last Tuesday, I think, the city IT guy or county, we didn't see the video that he got into evidence. Well, we saw a little bit just to, say, yeah, that's our video, just for admission purposes. But we didn't see the evidentiary part of the video. I'm hoping that today, under Buchanan on direct, we get to actually see that video. And I'm hoping that let me pull up my handy dandy Google Maps so that I say the correct street. But I'm hoping it shows Karen Reed at 12:30ish pulling off of Washington Street, making a right-hand turn. I should be faster than this at finding Canton. So turning right off of Washington onto Sherman. I'm hoping we see that today and that it shows the broken taillight. I don't know. I'm guessing there's a reason they put that video in evidence. There's a reason they put it in evidence. And I think Trooper Buchanan is who is going to show it to us. So that should be fun, because that'll just confirm. But as I was saying, though, it got even worse because we saw Karen Reed drink at least 7 units of alcohol in like an hour and a half. I believe the rule of thumb is an average person with an average metabolism will metabolize roughly 1 unit per hour. Still, if you're going to drive, just don't drink. If you're going to drink even 1 unit an hour, don't drive, because drunk driving is a scumbag move. But the and then we think she had more at the waterfall, maybe. Although, the smaller rocks glass that Johnny walked out with, that might have been his drink. We don't know. Of course, he'd been drinking Bud Light all night, other than 1 or 2 shots at McCarthy's. So it's possible that last drink of the night he switched from Bud Light to whiskey. But I'm assuming he carried Karen's drink out for her. I don't know. Either way, between that and the state crime lab DUI guy, not Larry Foreman, but who did the retrograde analysis, DUI analysis off of her blood draws and yada yada, she was driving drunk. That I'm sure of. That I'm convinced. I'm up there on her hitting him. She's still presumed innocent. The trial is not over. The defense has not had their say. So even if at the close of the state's case, they've got me sold, I'm still saying not guilty until the defense has its say. Now, if it were the other way around, if at the end of the state's case I thought, yeah, they haven't proved it, I'd say right then and there, she's not guilty. But no need to hear from the defense. Not guilty. Of course, the defense could fuck up so royally that they convince me the other way, but so, and Jennifer Ray, good to see you. I'm glad you're here to celebrate the US beating Pakistan in cricket with Paul. What was it? Was it a full 5-day test match, Paul? Or I assume, since it's international, not 2020 or one of the other short games. But that, and Vince, that's one of the stories. The problem with this defense is it really is the spaghetti defense, which, if that's what you've got, it's what you've got. Just try to create reasonable doubt wherever you can. And so, okay, so 2020, right? Or are you saying that 2020 is nonsense? So it was a test match. I know slightly more about cricket than I did before I lived in England, but still not a ton. Um, so okay, got it, Paul. But yeah, so just to me, yesterday was a devastating day for Karen Reed, for the defense. It's the day we've been waiting for. Everyone that's been saying, "Yeah, this is all nice, but show me the evidence of her guilt." And it's you know, I saw a lot of evidence of guilt yesterday. I'm not saying I saw overwhelming evidence of guilt, beyond reasonable doubt yesterday. Cumulatively, it might be there. I don't know yet, but we'll see. And the thing is, though, is the defense spewing Turtle Boy talking points, or is Turtle Boy spewing the defense talking points that they've carefully spoon fed him? Either way, it makes it, easier for me to discount, to ignore. But so one final point before we hit play. So I've mentioned pretty much from the start of the trial that I wouldn't be the least bit surprised to see Karen face new charges for conspiracy with Turtle Boy and potentially others. Conspiracy typically only requires two co-conspirators. Some conspiracy statutes will be like three people or whatever, but most require two. Um, and technically speaking, like you can conspire with an undercover cop. You can conspire with a confidential informant that has immunity. So not both conspirators don't have to be facing legal jeopardy. But in this case, I could absolutely see both Karen Reed and Turtle Boy facing conspiracy charges in the witness intimidation stuff, and potentially others along with them. Just, those two for sure. Maybe Papa Reed, maybe the attorneys, depending on what the evidence shows. Maybe Glare, maybe the Turtle Boys replacements. Pat's Cats, we've been waiting for you. I've been stalling just for you. Um, the but based on yesterday, I think another one of those added charges for a future court proceeding could be evidence tampering for Karen, maybe for her father as well. Because if they deleted that ring video, even though it was recoverable through a subpoena, through a different avenue, it's witness tampering or evidence tampering. And evidence tampering is a serious charge. It's usually a felony. So she could be facing that. I'm not saying she will. It's possible if she faces, if she is convicted of the second degree murder, top charge here, they don't see a reason to. But if she's acquitted or, just let's say gets a 5-year sentence or something, she could face more very serious felony charges. So that's a problem for her, or at least a potential problem. So, and 3 cents, I just got finished telling Pat's Cats, we've been waiting for you guys. That's why I've been stalling. Although it's really, just sort of a road so far. But yeah. So that's it. We've got 3 full weeks of conspiracy jazz hands. And yeah, the missing belt, the hat, the shoe apparently weren't so missing. Almost like the absence of Turtle Boy's knowledge that, they existed doesn't mean the state didn't have them. Because once again, Turtle Boy knew what the defense wanted him to know and spewed whatever he wanted to, because I'm sure he made stuff up. But, the state has the evidence, not Turtle Boy. So, and the testimony from the lab geeks, the one of the prior ones, I think the gray-haired one, maybe the one before her, was that they did scrapings of the sweater and got like taillight debris. Not big pieces, but taillight debris. And part of Yanetti's cross-examination was, well, you didn't find the debris on the clothing. You didn't even look at the clothing. And it to the next witness, to the final lab geek yesterday before Buchanan, you didn't even look at the clothing, and it was never in your possession. You did other analysis. Well, yeah, because we don't replicate work. We each have our own job. So you didn't do the scraping. So how do you know it even came off of there? And it's like, I didn't testify I did the scrapings. Someone else did. They already testified. You heard from them. But, just it's the defense trying to show that, yeah. And Snatch, there has been absolutely no evidence whatsoever that John was beat up. None whatsoever. Where's your evidence that the Commonwealth doctored evidence? But the FBI is watching. No, they're not. No, they're not. The FBI has nothing to do with this case. The feds even looking at it was completely inappropriate. Federalism still exists. The state is its own sovereign. The FBI is not, will not, never will swoop in and arrest everyone. Sorry to burst your bubble. And speaking of bursting bubbles, Brandon's here. So, hello. And it's yeah, Edwin, it's Turtle Boy's currently deep pockets are, I think, thanks to Karen Reed. And if it becomes a pissing match, like I've said, it those kinds of trials, it's who can get to the prosecutor first to make a deal. And I'm not saying she'd get full immunity to testify against Turtle Boy or vice versa, but you know, they absolutely wouldn't present a united front. There's just no way. Too much ego, I think, in both of them. And that's it. Where's the evidence? We've heard about scrapings, fingernail scrapings. If it was a fight, why there'd be DNA, there'd be fingernail scrapings. There why is it only the right side of his body? Why did none of the others have injuries? It's ridiculous. So, and that's it. The federal government can't interfere in a state trial. Now, there are habeas corpus petitions, but that's after. I mean, there are a few areas where you can be for, but it's generally you're going to have to petition to the state Supreme Court first, and then do a habeas petition to the federal district court. The FBI doesn't have anything to do with that. It's just, it's never going to work. It's, the free Karen Reed crowd keeps saying, yeah, the feds are swooping in any day now. But that's just not the way it works. Not this case, not any case. The only way would be like the Ahmaud Arbery killers or Derek Chauvin, Alec Murdaugh, where the feds charged someone as well. But that would have no actual impact on the state case. Now, if you end up with two separate convictions of different parties, yeah, it's wild. Absolutely wild, corrosive. But if you get two separate parties convicted in two separate courts for the same crime, well, someone's getting out on appeal. But in order for the feds to even charge, the reason Ahmaud Arbery, his killers, got charged in both, Derek Chauvin in both, is because it was a civil rights murder case. This one isn't. This one isn't. The Alec Murdoch, financial crimes. Well, the feds have jurisdiction of financial crimes, but so does the state. So that one, it didn't matter civil rights, but, the feds didn't charge Alec Murdoch for the murders because it wasn't a civil rights case. So, yeah, sovereign citizens' favorite word, jurisdiction. And the feds would have a real hard time exercising jurisdiction here. As I've said, the only thing I can think of for the feds would be the other soft sit favorite, 18 USC 241 and 242, deprivation of rights under color of law. But once again, that's civil rights. This isn't a civil rights case. Unless it's proven that the state tampered with evidence and, all that stuff. But even if she's found innocent, that's not a deprivation of rights, so long as the state, had the evidence, brought the evidence, showed the evidence, and the jury just disagreed. And with the McAlberts, it's not a 241, 242 violation because a big part of that is deprivation of rights under color of law. So let's pretend they beat the shit out of Johnny in the basement. Are they doing that under the imprimatur of police authority? No. It's not under color of law. So the feds can't go after the McAlberts for 241, 242. So it just wouldn't work. The feds are not, will never swoop in and arrest anyone in this case. It's done. And that's it. That's it. 3,500 pages. There's nothing. Judge Cannoni read it and said, yeah, I still can't figure out what the hell the defense is even talking about. It's dumb. D-U-M, dumb. Dumb, dumb, dumb. No. No. Very, very unlikely. And I assume you mean the threats to the McAlberts. But no, it would be Massachusetts. And yeah, the feds don't interfere in state cases. They just don't. Because once again, they can't. So all that being said, how about we press play? Because as I said, this is a very short day of court, but not if I keep yammering. So let's hit play.
Now, what we need, TV?
Could I see counsel at sidebar about a couple of things, please?
Brandon, you were wrong yesterday, but we got sidebar right off the bat today. So, so too bad you didn't make the bet today. And we've got glare front and center again today. Turtle Boy in the media. I don't see Corrosive's favorite diaper wearer. Just a little peek. Just a little bit. Zoom in on the crypt keeper. Boy, that glare really is aggressively chewing that gum. Ugh. I'd absolutely make him spit it out if I were the judge. But I can't stand the sound of gum smacking around in someone's mouth. And, ugh. If he's Mr. Burns, does that make little Alan Jackson Smithers? Inquiring minds want to know. Because I see that. I could see Daddy Reed being Burns and little Alan Jackson being Smithers. Is Mrs. Reed Patty or Selma? Or Agnes Abernathy, the cat lady? Exactly. Exactly. Or as I like to put it, it's rocket surgery. Those are the real geniuses, the rocket surgeons. I I hope Mrs. O'Keefe has an easier day today. Yesterday was brutal for her and for all of the O'Keefes, but I felt especially bad for Mrs. O'Keefe yesterday. Yeah, it's as I've said, I don't prejudge her on her guilt, but I do judge on the company you keep, and they're not keeping very good company. So it's just, ugh, ugh. The woman talking to Mrs. O'Keefe kind of looks like my aunt and uncle's former neighbor, like a cross between the neighbor and Becky, the courthouse clerk from the Murdoch trial.
What last place you're entering?
Brandon, no idea. No idea what they're talking about. I have a feeling about one of the videos or, some evidentiary matter, but no idea which one.
You are unmuted.
Exactly.
Sure.
Always love a good Mel Brooks
All persons have
reference.
any business before you want, Edwin Canody, Justice of the Norfolk Superior Court, in a copy of the notebook. Your name, give your attendance, and shall be heard. By the state of Commonwealth of Massachusetts, court is now open. May you see.
22117, the Commonwealth versus Karen Reed. Can I have the witness, please?
So, good morning again, counsel, and Ms. Reed. Good morning, viewers. We appreciate your patience. Giving us this time actually helps streamline things, so we appreciate that. I do have to ask you those 3 questions. Were you all able to follow the instructions and refrain from doing any independent research or investigation into this case? You were also able to.
So I mentioned yesterday, Appetite for Destruction was my first vinyl. I think Spaceballs was our first DVD, along with a few others, but Spaceballs was #1.
Follow the instructions and refrain from discussing this case with anyone since we left yesterday.
Yes.
Did anyone happen to see, hear, or read anything about this case since we left yesterday? Thank you very much. Everybody answered those questions appropriately. Okay, can we have Sergeant Buchanan, please?
Just for me a second. You solemnly swear never to give the court and jury in the case down here, should the truth, the whole truth, and nothing but the truth, so help you God.
I do. Thank you.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning, sir.
Circle
Down, boy, down.
back just to a couple things that from your testimony from yesterday. Going back to the video that you reviewed from both C.F. McCarthy's and the waterfall. In total, from those 2 videos, how many drinks did you observe the defendant consuming over her time?
The video shows 9 drinks being consumed by the defendant.
And that's between when she arrives at C.F. McCarthy's until the time that she leaves the waterfall. Is that correct?
That is correct.
And if I could turn your attention to the ring videos from 1 Meadows Avenue, Ms. Rose.
Brandon, that's clearly a lie. In Merb voice, clearly. Because just off of Mel Brooks alone, Robin Hood Men in Tights is better than Spaceballs.
Keith's residence. From the videos that you observed, let me ask you first, as far as, do you know how those cameras work as far as when they turn on and when they turn off?
My understanding is that ring surveillance video is triggered to be recorded through motion. So if the camera detects motion, which is constantly live monitoring, and motion is detected, then that video is captured to a cloud-based system that retains that footage.
And from your review of those videos, what kind of motion would set those off? Like what kind of things would be recorded from the driveway camera?
Be activity in the driveway, such as a person walking through, bird landing, a vehicle pulling in, individuals, moving around in the driveway, and so forth.
The search warrant that was applied for was any and all videos between January 24th and January 30th, correct?
For one of the search warrants, that's correct.
Except The Life of Brian is even better than that, because Life of Brian is the best movie ever.
Yes.
And with respect to that time frame, what, if any, activity based on information that you had received was not available or was not shown on those ring videos?
The data returned had video that would have been captured from the defendant arriving home after midnight on the 29th, after she dropped Mr. O'Keefe off at 34 Fairview Road. That video was not present in the data that was returned from Ring.
What, if any, other video in addition to that one was not present?
There was also video missing from the defendant showing Ms. McCabe and Ms. Roberts the damage to her right rear taillight.
And what, if any, follow-up or what, if any, inquiry was then done with regard to Ring as far as those types of videos or deletion or how those videos could?
So yeah, that's actually, that's a good point from Sergeant Buchanan. Something we forgot, in our discussion earlier today about the uncivil law video title or thumbnail, whatever, yesterday's court, defense, lying officer gaslights jury that red light is actually white. Well, the problem is we see it. Like, number one, we see it in that video that it's broken. There's still red, but there's white where it shouldn't be. But an hour later, when they all, when Karen, Jen McCabe, and Carrie Roberts all pull back into the O'Keefe driveway, but before going to 34 Fairview, Karen's pointing out the damage to them then. So, who broke it? If it, if as uncivil law is trying to claim it wasn't broken at 5:07, how did it break between 5:07 and about 5:50, 6 o'clock? Who broke it? How did they break it in that time? Karen was with them the whole time. She knew about the damage because she pointed it out to them. It's on video. We have seen that video. And we know it's broken before it gets to the Sally Port. We know it's broken before it gets to Dighton, to the Reed parents' house, because at 8 a.m., the Canton, can't remember if he was a sergeant or a lieutenant, but 8 a.m., the Canton officer pulls into the O'Keefe driveway to check to see if the kids were there unattended. And his dash cam clearly shows it broken. So we have 3 separate videos of it broken before it was towed from Dighton. So it wasn't smashed in the Sally Port. It wasn't smashed in the Sally Port. And I haven't watched any of their coverage, as I've said. I am though wondering what Emily's reaction was yesterday, because she is, in my experience, she analyzes things logically, and it's, until evidence of her guilt comes out, I can see Emily saying, yeah, I'm not buying this. But after yesterday, I would think Emily is at least closer. But we'll see. And I mean, during the Brooks trial, I mentioned, I'm usually a relatively quiet, reserved person, pretty shy. Takes me a while to warm up. And they're like, "What? No, you're not. You're, shouting and waving your arms and stuff." And it's like, well, yeah, but that's a put on for the camera. And so Emily's default reaction is outrage. I have a feeling part of that is for the camera. But yeah. So, but the thing is, Anne, once again, circumstantial evidence is good evidence. You know, the whole, oh, you only have circumstantial evidence is a movie trope that isn't actually a real life thing. You know, defense attorneys do try to sell it because, you know, you do anything you can. But, you know, the jury instruction at the end will say, hey, circumstantial evidence is evidence. It's good evidence. You can consider it and you can make reasonable inferences off of that circumstantial evidence. And that's it. That's it. The you know, circumstantial evidence is often better than eyewitness evidence, because eyewitnesses, as we have seen, suck. They really do. Because unless you're expecting to see a crime, you're not paying attention to remember the details of the crime. And then when you testify about it 2 years later, you know, you're off by 10 or 15 minutes because you weren't trying to remember it. You didn't know you'd be testifying about it in 2 years. And so eyewitnesses can really suck. Whereas the circumstantial evidence, you know, taillight fragments found in the snow near the body, it's physical evidence, but, you know, it's circumstantial evidence that John was hit by a car. And then, you know, fit it to Karen's, and you make the reasonable inference that it was Karen's car that hit John. So, you know, we don't see her driving drunk, but we see she's had 9 drinks in a 2-hour period, and, you know, the only 2 people that could have been driving are her and John. Well, John didn't hit himself, therefore, it was probably Karen. So, circumstantial evidence can be very powerful evidence. But, yeah. I did not see that one. I might not want to see it, but I think I do. But I think I do. So, yeah. And the thing is, you know, I get your criticisms of Lolly. I really do. I really do. But this is what closing arguments are for. This is where you get to make your arguments. You get to say, hey, remember all those puzzle pieces we gave you in the trial? This is how they all fit together, and therefore guilty. So, you know, it could take a while, but I do think he's getting there. I do think he's getting there. Of course, I haven't seen the jury. I don't know what the jury is thinking, but hopefully they're keeping an open mind, listening to the evidence with an open mind, and will do their best to think logically, even if, you know, they're not impressed by Lolly's level of passion. So, yeah. So, but by that token, though, and I also don't think, you know, as annoying as Poots was, can't remember the other defense attorney's name. I think I think Murdoch had a better defense team than, the clown show we've had here. So, Creighton Waters, I'll grant you, was better than Lolly. But I also think Poots and what's his name were better than Jackson and Yannetti. So,
Not present.
Correspondence with Ring produced information that
Sustain.
Let me ask this first, was there follow-up with Ring in regard to those videos?
yes, there was.
And was there ever anything produced with regard to those videos or those timeframes from Ring?
No, there was not.
If I could turn your attention over to your time in Dayton, just in reference to subsequent to that later on, what, if anything, did you receive, or what, if anything, did you request? What, if anything, did you
that is
receive
true.
from the Dayton Police in regard to January 29, 2022?
I communicated with the Dayton Police Department at our request, and log notes, logs from their dispatching center, as well as any reports that would document their activity if such reports existed.
And did you, what, if any, information did you receive in relation to that?
I received a log note or log printout from their CAD system, and I received a report authored by.
So, Pat, was it felony murder or was it like conspiracy to commit murder or something like that? I'm curious.
Officer Barrows.
And did you also receive any 911 calls?
Yes.
And who was the party as far as the 911 caller in regard to those 911 calls that you received?
It was Mr. Reed.
And again, just for clarity purposes, that's the defendant's father, is that correct?
That is correct.
And that's from the morning of January 29th, is that also correct?
Correct.
Now, sir, if I could turn your attention to February 3rd, 2022. At some point that morning, where did you go?
During the morning hours of February 3rd, we plan to meet at 34 Fairview Road. Myself, Trooper Proctor, and Trooper DeChico arrived at that location in order to conduct a secondary search of the area as the temperatures were turning and the snow was melting naturally. We decided to do another search for articles that were now, we realized and learned, were missing and could be of evidentiary value and aid in the in the investigation.
And with respect to going to 34 Fairview Road, what, if any, tools or what, if anything, did you bring with you, you and the other troopers, in regard to conducting that secondary search?
I requested the troopers bring shovels, rakes, anything like gardening items that would help them to dig through the snow and locate any missing items.
So I think it was also uncivil law. Might have been DUI guy. Just saw the thumbnail once again, but making fun of, oh, you had a shovel for the snow. It's like, yeah. Or sorry, a broom for the snow or a rake. It's like, yeah, like if there's a like less than an inch of slush on the driveway, the reality is sometimes a shop broom, a push broom, is better for moving that than a shovel. But, with large amounts of snow, if you want to move it little by little in layers, that broom might be a better tool than a shovel where you take out big globs of snow. And yeah, it's like, are we watching court or are we watching, wrestling? But yeah.
And as far as the temperature change that you're talking about, how precipitous a change are we talking about?
The temperatures went above freezing, so the snow did begin to melt, and it was significantly warmer compared to the 18 degrees the night of the incident.
Now, you mentioned items of evidentiary value that you had learned of and were looking for. What, if any, clothing items, Mr. O'Keefe, were you looking for specifically on February 3rd?
We were specifically looking for Mr. O'Keefe's baseball cap.
And in addition to yourself, Trooper Proctor and Trooper DeChico, who Who, if anyone else, did you notify, or who, if anyone, from any other unit within the state police responded that day as well?
We requested the assistance of the Crime Scene Services section of the Massachusetts State Police, and Trooper Evan Brent showed up to assist us with documentation of the location and the evidence that we were hopefully going to find.
And from those, Trooper Brent arrived and took photographs, is that correct?
That's correct.
And when was it that Trooper Brent arrived in relation to your arrival?
I believe he was already present when we pulled up, but I'm not sure to his exact time of arrival.
And with regard to that day, what, if anything, in general terms, what, if anything, were you able to locate and where was it generally speaking?
We located Mr. O'Keefe's baseball hat. We located a drinking straw from a cocktail glass. We located items of plastic, colored plastic, and other shards of colored plastic at the location. All those items were located on the grass portion of the yard near the flagpole at 34 Fairview Road.
And Your Honor, may I please?
Yes.
Your Honor, may I have a moment?
Yes.
And Sergeant, I'm going to show you a series of photos, but I'm going to break this up a little bit.
So, Mr. Lally, with your back to the jurors and the air conditioning on, I'm sure they can't hear you.
3 cents. I probably go Celtics. Probably. But I don't have a dog in that fight, so yeah.
My apologies. So, sir, what I'm going to do is I'm going to show you some photographs, a series of them, but I'm going to break them up a little bit just to make it, okay, sir, hopefully quicker. So first I'm going to show you 10 photographs. Ask if you could view those, look up when you're finished.
And Kat, I didn't have the sound on, obviously, but I just looked at that on my phone, and it looks like it's about what we talked about. You know, John's car didn't move, didn't rock, nothing left in the snow. Zoom in, and the taillight's broken at 5:07. There's still red light, but there's white light where it shouldn't be. So yeah, Karen Reed, professional liar, as the title of that short says. So yeah. And as I said, Corrosive, I don't know if you were here when I did, but you know, they're saying, well, there's still red, and it's like the videos we've seen of the broken taillight, there's still like a third of the red lens is there. But an intact Lexus taillight has no white light on the passenger side. That video shows white light on the passenger side, therefore it's broken. And so, and it just, they're watching a different trial than we are. They're watching a different trial than we are. Because we see 3 separate videos where it's broken. And as I said, I'm hoping, no spoilers, I'm hoping we see her driving, you know, making the right turn off of Washington onto Sherman at 12:30, 12:40. Because that video's in evidence, so if it picked it up, I'm hoping we see it and see that it's broken at 12:30, 12:40 as she's driving home. But and that is a good point. I don't know for sure that they're red LEDs under the red lens as opposed to white, and just colored by the red lens. But that's actually a very good point. They might actually be red LEDs, and the misplaced white light we're shown is just because there's no red lens to block it. But yeah, that's a very good point. So
Thank you. Do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Those are photographs documented the items located at 34 Fairview Road on the grass as the snow receded through the melting temperatures that were revealed to be positioned in the grass.
And what's contained in those photographs, is that a fair and accurate portrayal of what you observed on the front lawn area of 34 Fairview Road on February 3rd?
Yes, it is.
Your Honor, may I approach?
Yes.
I'm off to introduce the minutes and exhibits.
Any objection, Mr. Jackson?
No objection.
Okay.
the thing is, even in a $75,000 car, they cheap out where they can. It is the unfortunate truth.
Thank you.
And Your Honor, with the court's permission, if I could just ask to publish some of these photos.
Yes.
Just one moment, Your Honor.
Sure.
And Ms. Gilman, if I could start with photograph 7659. And Sergeant, do you recognize what's up on the screen, what's now been marked as Exhibit 468?
I do.
And if you could, just for orientation purposes, describe the majority whereabouts in relation to 34 Fairview Road we are in this picture.
As standing on the street of Fairview Road, we're looking at the left side of the yard. In the top right corner, you can tell that there is a flagpole depicted in that photograph and a telephone switch box that's open on the left side, which is on the border of 34 Fairview Road.
And if I can ask from this photograph, if you know, grass that's visible on the front lawn area of 34 Fairview Road, is that from a natural melting process, or is that from some tools that you and the other troopers brought to assist you in your secondary?
The reason that grass is exposed is due to processing of the scene and having the snow being moved away from the location, and then natural melting process taking place on top of it. As you can tell, other portions of the yard is covered in snow, and the snow had not, the grass has not revealed itself just yet.
Now, as far as the photographs of various items that were located on this date of February 3rd, the photographs that were they taken as they lay, or were they touched or manipulated in any way prior to the photograph being taken?
The items photographed were discovered as soon as we realized what is being discovered through the digging and excavation process. They were then photographed instantly. Certain items were revealed naturally through the melting process and the snow, no longer concealing those items underneath.
Thank you. Ms. Gilman, can I have photograph 7666?
7666. Oh, what a lucky devil.
And again, sir, do you recognize what's up on the screen? It is now been marked as exhibit 470.
I do.
What do you recognize that?
That is a clear black and red piece of plastic.
And Ms. Gilman, if I could have photograph 7669.
But those were pine cones.
And Sergeant, do you recognize what's now on the screen as exhibit 473?
Yes, that is another piece of plastic.
And sort of towards the top middle of the screen, do
Yeah.
you recognize what that is?
Imagine that, Edwin. A deceptive picture used by the defense. I'm shocked.
Yes, that's a fire hydrant from 34 Fairview Road, grass area.
Ms. Gilman, if I could have the next photograph 4670. For the record, this is exhibit 474. Do you recognize that, sir?
Yes, sir.
Is that a closer up image of what was depicted in the prior exhibit?
Yes, it is.
And Ms. Gilman, if I could have photograph 7672. And sir, you recognize what's up on the screen, which has now been marked as exhibit 476.
I do.
And what do you recognize that, Steve?
Another piece of red taillight plastic.
And lastly, from dispatch, Ms. Gilman, if I could have photograph 7673. Again, sir, do you recognize what's up on the screen? Depicted?
You got her, Vince. You got her. You got her. Chloe didn't like the intrusion onto her potty area.
What's now marked as exhibit 477.
I do.
What do you recognize that?
That is the fire hydrant and the telephone switch box located on the edge of the property line at 34 Fairview Road.
Now, the photographs that I had just placed before you, haven't you had a chance to review those?
I have.
And do you recognize what's depicted in those photographs?
I do.
And what do you recognize those?
The property at 34 Fairview Road, left corner towards the street, capturing the flagpole and the telephone switch box.
Mayor Pro Tem,
Yes.
call multi to introduce and admit as the next exhibit. Okay.
Okay.
The jury will have the photos in the deliberation room, so they'll get to see it.
Thank you.
Your Honor, with court's permission, if I could publish a few of the photos from this set.
Okay.
Ms. Gilman, if I could have photograph 7681. Sergeant, do you recognize what's up on the screen? It has now been marked as exhibit 481.
I do.
If you could describe to the jury what's depicted in this photograph.
A red piece of plastic.
And Ms. Gilman, if I could have the next one, 760.
Can you use the pointer to show us where that is, please?
Yes, Your Honor.
Yeah, that one
All right,
is
thank
hard
you.
to see.
Ms. Gilman, 7682. And
Well, the
Sergeant, do you
close-up.
recognize what's depicted on the screen and has now been marked as exhibit 482.
I do.
You know, I'm going to see counsel at sidebar for just a minute, please.
Is this cumulative? Like, let's move it the fuck on? But, once again, in order for this is the process. So, unfortunately. Oh, the jury's in. They could have seen that, whatever that was. Maybe the mask is slipping. She's forgetting that the jury is there.
You are unmuted.
I'm sorry, Ms. Gilman, 7682. Sergeant, do you recognize what's up on the screen as Exhibit 482?
I do.
What do you recognize that to be? Is
A red piece of plastic.
that the same piece of plastic that close-up image from the prior exhibit?
Yes, it is.
And Ms. Gilman, if I could have photograph 7684. Sergeant, do you recognize what's up on the screen and is now marked as Exhibit 484?
So there's
I do.
the glass right there.
And,
Realize my mouse only shows up if I'm paused. So there's the clear, I said glass, but I guess it's plastic, right on the edge of the snow, and red plastic right here between the two brown leaves.
lastly, from this, sir, Ms. Gilman, if I could have 7687. So again, do you recognize what's up on the screen? It's now marked as Exhibit 487.
I do.
Now, Sergeant, with reference to the photos before you, have you had a chance to review that set of 10 as well?
Exactly.
Not this one yet, not yet.
If you could, please.
Can't tell if this one's glass or plastic. I think it's plastic.
And Sergeant, do you recognize what's depicted in those photographs?
I do.
What do you recognize those to be?
Items that were located in the street, being the black cocktail drinking straw, and then black pieces of plastic, molding plastic, and clear pieces and molding from taillight.
May I approach, Your Honor?
Yes.
Almost 60 minutes the next time. Sir?
Any objection, Mr. Jackson?
None, Your Honor.
But I've got my 27 inch monitor right there. When I'm looking off to the side, that's what I'm looking at. So I'm assuming a good portion of you are either on a laptop or on a phone or whatever, and it's not as big. The jury, as you've seen, it's on a projector, so hopefully they're able to see it. But once again, the witness should be using the laser every time, the laser pointer every time, to say, yeah, right there. Look at that right there.
Thank you.
Thank you. Your Honor, with the court's permission, if I could display some of these photographs to the jury.
Okay.
Ms. Gilman, if I could have 7688. And Sergeant, do you recognize what's up on the screen?
I do.
What do you recognize it to be?
It's the wide shot of the drinking straw being found on the edge of the roadway in front of 34 Ferry Road.
Sergeant, if you could, using the laser pointer before you, if you could direct your
It's this one. It's on the tar stripe, so it's hard to see. There's this green something right next to the curb. It almost looks like, you know, when you get a new roll of Scotch tape, the green bit at the end so that the roll doesn't stick to itself. Looks like that with a little bit of tape on the side. But that could be like a sticky label or something. But yeah, there's a little green thing right there. Don't know if that's evidence or just general debris. But yeah. And yeah, the leaves are part of the conspiracy. Rush sang about the trees. So Geddy Lee is in on it. Hell, all of Canada is in on it because Rush is a Canadian icon. Tolkien wrote about the ants, giant tree people things. So Tolkien was in on it. That puts Oxford University in on it. All of the old, Oxford colleges have religious names. And it pre-Reformation, so Catholic Church. Remember, we're on the Gregorian calendar, Pope Gregory. Boston, full of Irish Catholics. The conspiracy's coming together. The leaves prove it. You're onto something, Surrender Monkey.
Jury's attention to where you observe that straw. And Ms. Gilman, if I could have 7689. Sergeant, what are we looking at in this photograph?
Now
So
you can see the
close-up view of
straw.
the same straw.
Ms. Gilman, if I could have 7692. Sergeant, do you recognize what's up on the screen? It has now been marked as Exhibit 492.
I do.
And what are we looking at 492?
Piece of plastic next to a measuring ruler that's provided for comparison and by the crime scene photographer to document the item.
And that one is really hard to see. It's between the snow patch below the fire hydrant and the ruler. Just it almost looks like a shiv, like a blade shaped piece of clear plastic with a little black plastic on the end.
And Ms. Gilman, if I could have 7695. For the record, this is now Exhibit 494.
Oh,
Sergeant, what are we looking at 494?
and a red
It's
blade.
the same item from just prior, just zoomed in more, showing the detail, the black molding, the clear clear plastic and red plastic.
Sergeant, as far as those photographs before you, have you had a chance to review those?
Yes, I have.
And do you recognize what those are?
Yes, I do.
What do you recognize those?
There are pieces of red plastic, pieces of clear plastic, and a piece of glass.
May I approach, Your Honor?
Yes,
I'm about to seek to introduce the Ms. Next exhibit. No objection.
thank you.
You know the score, Gray Duck. That's, yeah.
Exhibit 498, jury, 508.
Thank you.
Thank you very much. Your Honor, with the court's permission, if I could publish just a few of these photographs for the jury as well.
Okay.
And Ms. Gilman, if I could have photograph 7700. For the record, this is now exhibit 498. Sergeant, if you could describe to the jury what we're looking at here.
Okay, the lighting on this one is a lot worse, but you can see the evidence ruler, and it's just to the top left piece of red plastic right on the edge of the snow. Well, on the grass, right off the edge of the snow.
We're looking at a red piece of plastic next to a measuring ruler on the edge of the grass on the property at 34 Fairview Road by the road.
And if you could
I know
start
the
using that
feeling.
laser pointer, just direct the jury's attention to where you observe that item to be within this photograph.
Right there.
Ms. Gilman, if I could have photograph 7705. And for the record, this is exhibit 502. Sergeant, if you could, again, describe to the jury what, if anything, is.
So red plastic right next to the ruler, and there's something right here next to the snow. I think it's white plastic with a little black on the top left end of it, but
significance you know in there.
It's a shard of red plastic next to a measuring ruler.
Ms. Gilman, if I could have photograph 7708. For the record, this is now exhibit 504. Again,
looks like white plastic toward the top of this leaf and maybe some black at the bottom of the leaf. So, yeah.
Sergeant, if you could, using a laser pointer, direct the jury's attention to what, if anything, of significance you know in this area.
There is a black piece of plastic molding next to a measuring ruler.
And lastly, from this set, Ms. Gilman, exhibit, photo number 7712. Again, for the record, this is exhibit
So-
508. And again, Sergeant, if you could, using the laser pointer, direct.
Clear plastic, 6 centimeter triangle of clear plastic right here.
Jury's attention to what, if anything, of significance you know in this.
A clear piece of plastic next to a measuring ruler.
That's found on the grass area as well, is that correct?
That is correct.
Now, Sergeant, with reference to that new set of photos before you, have you had a chance to review those?
Yes, I have.
And do you recognize what's contained within those photographs?
Yes, I do.
And what do you recognize that those photographs to contain?
They contain small red pieces of plastic from 34 Fairview Road on the grass area where we located the others. Also contain a flimsy piece of circular, like very malleable plastic, clear plastic.
I've wondered about that. I mentioned the circular piece of plastic a couple days ago. Mentioned it looks like a CD case to me, like not the square CD case that when you buy a music CD, but like the cheap ones that, like if you got a burnable CD, just the circular clamshell CD cases is what it looked like to me. Kind of, but I don't know what it is. So.
In addition to that.
May I approach, Ron?
Yes.
Come on, seek to introduce the minutes of the next 10 exhibit. Objection.
Thank you.
And part of the reason they're just trying to speed through this is like these photos aren't to show, hey, this is the evidence itself, because the fragments are what matters. And so, they're not collecting rose leaves and bringing them into court. They didn't put rose leaves together to make the tail light. This is the primary reason they're showing these photos is this is how we found them. This is how we found them. Then we picked them up and then we analyzed them. And that's the important evidence we want you to consider. It's just, we want you to see this is how we found them. And also, as I said, the jury will have these, they'll, assuming they're, admitted, not just published, but assuming they're admitted exhibits, and I see no reason they wouldn't be, the jury will have these in deliberation. So even though they're just very brief glances in the courtroom, they'll get to see them and they'll get to say, oh yeah, this is that piece right there. So it's fast, but the reality is it really is fine because they'll get to consider it in deliberation much better. So and I'm going to say they absolutely do not have a shot at the directed verdict motion because the state basically, to win the directed verdict motion, there has to be an element of the crime that's completely missing evidence. So not that the evidence isn't believable, but that it's completely missing. Like they forgot to identify the defendant. They haven't introduced any evidence about her blood alcohol content. They haven't introduced any evidence that she was driving that night. And they have. They've introduced evidence of every element. The judge doesn't have to believe that evidence, but if it's introduced, the defense can't win the directed verdict because the jury gets to weigh the evidence. The jury is the finder of fact. So, directed verdict at the end of the state's case, the only way to win that is if there's completely missing evidence. And that's not the case. That's not the case. But the thing is, causation isn't necessarily an element. It's I mean, so obviously something has to have caused Johnny's death, but the reasonable inferences, there's evidence to make a reasonable inference that she backed into him. And juries can make reasonable inferences. So it's just, it's there. Once again, I'm not saying the jury has to believe it. I'm not saying the jury has to make that inference. Just there's absolutely no way that a directed verdict will be granted. So, yeah. the painted Bronco, I don't think that the DUI manslaughter is a lesser included. I think that's a completely separate charge. I don't think it would merge with the second-degree murder charge if she's found guilty of both. Regular manslaughter would merge. I don't think DUI manslaughter does. Once again, I'm not a Boston attorney or a Massachusetts attorney. I could be wrong on that, but they shouldn't merge. So, yeah. Possibly if she's found guilty of the second-degree murder, it's possible. It's possible. So,
Thank you. And Your Honor, may I publish some of these photos for the jury?
Yes.
Ms. Gilman, if I could have photograph 7715. For the record, this is now exhibit 511. Sergeant, direct your attention to the screen if you could, using that laser pointer, direct the jury's attention to what, if anything, of significance you observe in this photograph.
That is the thin, malleable, circular in shape, a piece of clear plastic that was located in the lawn area of 34 Fairview Road.
and so, yeah, that's clearly not a clamshell CD case. It's just, it looked to be about the right size. I think it's thinner plastic, and, he said malleable. So I don't know what it is, unless it's like, the protective coating. Like, she didn't peel the film off of the taillight when the car was new. I don't know what that is.
Now, lastly, Sergeant, there's that set of photos that I just placed before you. Yeah, have you had a chance to review those?
Yes, I have.
And do you recognize what's depicted in those photographs?
Yes, I do.
And what do you recognize those to be?
There are items. Those are items recovered in the lawn at 34 Fairview Road. Those items are a shard of glass, a BPD baseball hat with the American flag, and stains of blood.
Your Honor, may I approach?
Yes.
I'll also introduce.
And it could be that. It could be that. Yeah. But I will say, though, Anne, as a defense lawyer, you're the kind of juror I want on the jury. Skeptical and hard to convince of the evidence.
Next. No objection. Sorry, no objection.
Yes. She made a face as they approached once. So, yeah. Of course, with Turtle Boy, I realize he's not a large man anyway, but I'm not overly tall myself. the funny thing is, I have a cousin that's 6 inches taller than me. Yet, if we sit next to each other on a bench, we look basically the same height. The difference is entirely leg length. And, that's not an amputee joke either. He just has freakishly long legs, whereas I have more torso. And so, but we do know that Turtle Boy doesn't have freakishly long anything under there either. So, yeah. He does on the inside, Kevin. And unfortunately, when I say he doesn't have freakishly long anything, I don't want to give you the imagery, but there is the couch video out there, and ugh, no one wants to see that mushroom.
It's 5:18 to 5:30.
5 what?
Therefore, you are-
Thank you very much.
Thank you. And Your Honor, with the court's, I'm sorry.
Jim.
Your Honor, with the court's permission, may I publish some of these photos for the jury as well?
Yes.
Except Dahmer's a foot taller than him
And Ms. Gilman, if I could have photograph 7727.
and a little less creepy.
For the record, this is now exhibit 520. And again, Sergeant, if you could direct the jury's attention to what, if anything, of significance you observe in this photograph.
I observed a shard of glass next to a measuring ruler.
And Ms. Gilman, if I could have 7729. For the record, this is exhibit 522. And again, Sergeant, if you could abstract the jury while we're looking at it.
It's a larger piece of red plastic with black molding around the
And this looks like the electrical utility box, whatever it is.
edge, located next to the telephone switch box on the grass area at 34 Fairview Road.
And Ms. Gilman, if I could have photograph 7733. For the record, this is exhibit 526. Sergeant, from this photograph, what, if anything, are we looking at here?
This photograph here
Sorry about that, Grey Duck, and everyone else.
depicts the area which we are excavating during the morning hours of February 3rd, 2022. As the shovel works its way towards the grass, my laser pointer is directing your attention to Mr. O'Keefe's hat that was compacted underneath the snow on the ground.
Now, as far as this photograph is concerned, is that accurate?
And you can see that's at the very bottom of over a foot of snow. It's on the grass. So, yeah.
How do we depict the depth of the snow that you would?
It's almost like, where's the hat? Where's the hat? How come the hat wasn't in the ambulance? Da, da, da. It's like, because it's under all that snow. Yeah. CSI would have come in with like we've made the Spaceballs comb the desert joke. They would have come in with the hairdryer to match the Spaceballs comb and melted all the snow. So, and that's it. That nothing shows conspiracy like planting the evidence ahead of time. That's, yeah.
Digging into and sifting through on the morning of February 3rd.
It does.
And that again is several days after the blizzard of January 29th, correct?
That is correct.
And Ms. Gilman, if I can have photograph 7740. For the record, this is exhibit.
And I believe there's one on the witness list. So, just be patient, and I think you'll get what you need there. Oh, delete laws would be furious. It's a blue line gang hat terrorist much.
5:30. And again, Sergeant, if you could describe to the jury what we're looking at here.
We're looking at Mr. O'Keefe's hat on the grass, pressed down and compacted to a flat surface underneath the snow, which has been excavated around it.
Thank you very much. Ms. Gilman, you can take that down.
That's what it says to me.
Thank you, Mr. Ross.
Thanks.
Sergeant, on
But, you know, according to the defense theory, if it doesn't all fall straight down, it's a conspiracy. Whereas, you know, law of conservation of momentum, you smash and the car suddenly stops, the broken taillight fragments aren't going to suddenly stop because they still have all that momentum. And until that momentum runs out, they're going to keep flying. So, yeah. That guy is a maroon. I mean, moron. So,
February 3rd, 2022, is that first time that you had been at 34 Fairview Road?
Yes, it is.
And with respect, if I could turn your attention briefly to the following day of February 4th, did you have occasion to go back to 34 Fairview Road on that day?
Yes, I did.
And what brought you to 34 Fairview Road on February 4th?
Having excavated those items on the 3rd, I directed the troopers in my office, who obviously reside.
I think they're equally. I actually put Eline as a bigger grifter just because he should know better and he has other options. But yeah. That's not a quick answer is the problem, Kevin. But the argument would be that they have availed themselves of that jurisdiction in such a way to provide that county court with long arm jurisdiction. Of course, I believe that long arm jurisdiction doesn't actually exist in that case. It's just delete laws lied, is my belief. But yeah, there shouldn't be long arm jurisdiction in that case. So that's the short answer. So, but there is that, you know, the defamation reached into California, except he wasn't in California. He doesn't live in California. Yeah, it's just, there's all kinds of problems with it. But unfortunately, even the defendant with a lawyer in that case didn't start off with a lawyer, and the lawyer had to clean up some of the mess, and it's just, yeah. And the problem is that by suing, what's his name, Daniel Clement, who lives in California, there was no diversity jurisdiction. So, yeah.
In the communities around us to make a point to travel by that location every day on the way to work and every day on the way home. The purpose of that was to see if anything else was to reveal itself as the snow naturally melts away and items could present themselves. So on the February 4th, as I am traveling to work, I diverted my typical route of travel to go by 34 Fairview Road. Just prior to my arrival, I received a call stating that there was Kent police representatives at the scene, and more items have been revealed due to the melting snow, and that I should come collect those items.
And remember, Canton Police not doing the investigation, but we've had testimony. Yeah, the staties do it. They're the ones with jurisdiction, but we assist. We assist. So it's not inappropriate for the Canton Police to be assisting.
I was down the street. I arrived and collected the item that presented itself.
And if you recall, that item that you collected on February 4th, was that located on the lawn, on the street, or something else?
It was on the lawn.
Now, with reference to your collection of these items, either on February 3rd, February 4th, or on any sort of subsequent date, how were they collected, and what exactly did you do with them in reference to the seizing of the items and storage of the items?
Each item that was collected was placed in a evidence paper bag. The collection was done by utilizing latex gloves to prevent any transfer of evidence from fingerprints to DNA onto those items. Then those items were transported to our office, logged into the system, and stored in the evidence lockers at the office.
And each of those respective bags of items or evidence, they were sealed as well, is that correct?
That's correct.
Now, turning your attention to February 10th of 2022, did you have occasion to go back to 34 Fairview Road on that day as well?
I did.
And what, if anything, did you observe, or what, if anything, did you seize on that particular day?
We seized more shards of glass and plastic.
And if you know, or if you recall, how many pieces did you seize on that particular day?
My memory is exhausted to that, but the exact numbers annotated in on the bags that the items were placed into.
Your Honor, may I approach?
Yes.
I'm showing you.
You can tell he's a professional witness. Yeah, my memory's exhausted. I can't remember off the top of my head. My memory's exhausted.
Documents just ask you to look at that section and look up what it is. Your Honor, may I approach?
Yes.
Sergeant, is your memory refreshed as to how many items or what the items were that you recovered on February 10th?
Yes, it is.
And what were those items and how many, sir?
There was 6 items of clear red and black plastic and 14 items of plastic and glass.
Now, in addition to
Not from a state trooper. Some witnesses, it's what I'd expect, but not from a state trooper.
that you were present at 34 Fairview Road and recovered items, them being February 3rd, February 4th, and February 10th. Were there other dates that you're aware of that items were recovered by troopers that you supervised?
Yes.
And if you recall, what were those dates?
The dates were January 29th, February 11th, and February 18th.
Were there items recovered on February 8th as well?
Yes.
Now, as far as your direction or having, let me first start with you. So on the dates that you were there, February 3rd, 4th, and 10th, were you alone on those dates? Or were there other troopers with you when you were there?
On the 4th, I was alone as far as state police personnel. There were other Canton law enforcement representatives at the scene with me as I collected that one item. On the other days, I was accompanied by other troopers.
And as far as you know, obviously not being present, but from your supervision of these troopers, were there other occasions where individuals were at 34 Fairview Road? Were they alone or were they with a group of troopers? Objection.
Sustained.
Now, as far as the items that were recovered when you were there on February 3rd, February 4th, and February 10th, did you have occasion to bring those items with you for today?
Yes, I did.
Your Honor, may I approach?
Yes.
I'm sending you with the box. First, just ask if you recognize that box.
I do.
And what do you recognize that?
It's the box storing items logged into evidence as they relate to.
Today we get an actual unboxing. We called it an unboxing yesterday, but it was really an unbagging, debagging, unbagging. But today we get an actual unboxing, so hooray!
To this case.
And, Your Honor, with court's permission, may the sergeant open the box?
Yes. Thank you.
Now, First Sergeant, with regard to the items, as far as plastic and/or glass that you recovered from 34 Fairview Road on February 3rd, if you could locate those items.
Oh, now it's unbagging. Shall I put you in touch with the manager, Grey Duck? They absolutely bring the murder weapon when they have it.
And Sergeant, with respect to each of those bags, they contain items of evidentiary value, whether they be plastic or glass, that were recovered on February 3rd. Is that correct?
Ooh.
That's correct.
And I'm sorry, how many bags in total do you have there for you?
I have 3 bags, 2 containing broken glass and plastic, and a steering straw, broken red plastic and clear plastic, and a bag containing 1 black Boston Police Department hat.
You're going to come up to seek to introduce in minutes the next 3 exhibits.
No objection.
Okay.
No particular order.
Yes. 5:35, 5:36, and 5:37.
It's other than like dress uniforms. For a detective, the suit is the uniform generally. So, yeah.
Thank you.
Your Honor, with respect to what's now marked as Exhibit 537, with court's permission, may the sergeant remove that item, the hat, from the bag and display for the jury.
Yes.
If they want it as an exhibit, yep. Ah. Oh, that's good to know. As I've said, I haven't read the pretrial rulings intentionally, but yeah, if the judge said, hey, out of uniform, wear your civilian clothes, don't prejudice the jury, of course. I generally don't have an issue with law enforcement testifying in uniform, but yeah, so, and yet we had Dumbass the Clown show up in a t-shirt yesterday with a photo of his judge or his prosecutor with a clown nose, because that's okay. It wasn't okay.
Thank you, sir. You can place that back in the bag.
The thing is, the free Karen Reed nonsense, there's no way the judge would have let that in anyway. Like, I can see the judge saying, yeah, whatever, both are out, just to keep them happy. But the free Karen Reed crowd, or clothing, whatever, it's a general rule that you can't wear inflammatory or inappropriate or whatever. And, I can see, let's say, if the O'Keefe family said, yeah, let's have the back row of the family seating, let's have Boston police officers, and they all showed up in uniform every day. Yeah, that would be inappropriate. Brian Albert showing up in his uniform, I can see that being inappropriate since he's testifying as a civilian who happens to be a cop. Like, he's a civilian witness who happens to be a cop. And Higgins, and, whereas the investigating cops who are not, civilian witnesses would be different. So, but yeah, so either way, if it's what the judge ruled, it's not a big deal. It's not a big deal. It wasn't necessary, but it's not a big deal. I see it being a bigger deal for those in the gallery. Of course, if, let's say, the defense calls Karen Reed's father to the stand and he wears a, free Karen Reed, hang Judge Cannoni, that would be inappropriate. Highly inappropriate. Wearing it in the gallery is also, but, if a witness wore that, boy, that would be awful. So, probably once the jury leaves, but.
Sergeant, from your observations of Mr. O'Keefe on surveillance video from both C.F. McCarthy's waterfall on January 29th, what, if any, similarities did you observe between the hat just displayed and located on the lawn of 34 Fairview Road and the hat Mr. O'Keefe is wearing in those videos?
It appears to be the same exact hat.
Now, Sergeant, with reference to the box of other items, if you could remove what, if any, items you recovered and seized from 34 Fairview Road on February 4th. And again, sir, just for the record, what's contained within that bag from February 4th?
Contained within the bag is a piece of red, hard plastic taillight cover.
Your Honor, the Commonwealth will seek to introduce in the minutes the next exhibit.
No objection.
Thank you. Exhibit 538.
And lastly, Sergeant, with regard to the box, if you could remove the items that you seized from February 10th, 2020. And Sergeant, with respect to those two bags of items, if you could just inform the jury what is contained within those bags.
Bag labeled item number 10 contains 6 pieces of red, black, and clear plastic. Bag labeled number 11 is containing 14 pieces of glass.
I think that's the defense theory, but yeah, I don't know how, but that's the defense theory.
Plastic fragments.
Thank you, Sergeant. Your Honor, the Commonwealth seeks to introduce and admit as the next two exhibits.
Any objection, Mr. Jackson?
Sorry, no, Your Honor, thank you.
Exhibits 539 and 540.
I'm sorry, was it 539 and 540?
Yes.
Thank you, sir. Moving on from that, if I could bring you back just one last time to ring videos from One Meadows Ave, as far as you had testified earlier that there was no video that you observed of the defendant, Ms. McCabe, and Ms. Roberts looking at the passenger side taillight area of the vehicle, correct?
That's correct.
Was there any video of the defendant, Ms. McCabe, and Ms. Roberts actually leaving from One Meadows Ave on that morning of January 29th?
There was not.
Now, as far as the videos that were not there, as far as the defendant, Ms. McCabe, and Ms. Roberts leaving, The next video depicted Mr. Camerano arriving at the residence to pick up Ms. Furbush, correct?
Yes, that's correct.
And with regard to the missing video of the defendant,
Okay, so yeah, we didn't see video of them looking at the taillight. We just heard testimony about them looking at the taillight. So, sorry.
arriving at One Meadows Ave on January 29th, sometime after midnight. The video immediately preceding that, again, would have been Mr. Camerano arriving and picking up his daughter from One Meadows Avenue sometime around 11:30 p.m., correct?
That's correct.
And those videos were both present, correct?
That's correct.
If I could bring you back to February 3rd, 2022. On that date, did you have occasion to meet with a gentleman by the name of Brian Higgins?
Yes, I did.
And when you met with Mr. Higgins, who, if anyone from your office, was with you when you met?
Trooper Mike Proctor was from my office present during that interview.
And during the course of that interview, what, if any, documentation did Mr. Higgins provide you with?
Mr. Higgins provided me with a printout of a Celebrate extraction containing conversations via text message between him and Mr. John O'Keefe and between him and the defendant. He also provided a digital copy of the same extraction on a CD.
Now, what, if anything, did you advise Mr. Higgins of at that time as far as Mr. O'Keefe's phone and the defendant's phone?
I advised Mr. Higgins that we were in possession of both of those devices and would have the extraction and accurate documentation of those conversations.
And did he seem to understand that when you told him?
Yes, he understood it.
Objection.
Sustain.
Move to strike.
Strike that, folks.
Sergeant Buchanan doesn't know the contents of Brian Higgins' mind. He doesn't know that Higgins understood. So.
Now, also on February 3rd, at some point, did you have occasion to go inside of 34 Fairview Road?
Yes, I did.
And who, if anyone, did you interview inside of 34 Fairview Road on that day?
I interviewed Mrs. Albert.
That would be, just for the record, Nicole Albert, is that correct?
That's correct.
And who, if anyone, was present with you during that interview of Nicole Albert?
It was Trooper Mike Proctor was present with me.
Anybody else from the Albert family present in the home or present during the course of that interview?
Mr. Brian Albert was also present. I don't know who else exactly was present in the home. I just know that those two residents were in the room with us.
And where was Brian Albert at the time that you conducted the interview of Nicole Albert?
They absolutely can take notes and are, because, you know, we keep hearing, leave your notes right here. You don't get to keep your notes until deliberations, but I'm hoping, in addition, at closing, you know, some people criticize PowerPoints at closing. I'm hoping Lolly has a PowerPoint, you know, with the timeline. This is when this happened. This is when this happened, and da 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 da, and yeah. So.
In the room with us, seated next to her.
Now, with reference to, I'm going to ask you just a little bit about sort of the interview process as far as the interviews that you conducted in this case.
Yes.
If you could describe for the jury, starting with sort of how many people from your unit are present for a given interview and how those interviews are conducted.
We conduct interviews always in pairs. I think I mentioned it yesterday. Typically, during a regular investigation into a homicide or any death investigation, we pair up our troopers with a local detective. In this instance, since Canton had recused themselves from interview portion of the investigation, they were not going to provide manpower for those interviews to be conducted. Thus, we had to utilize only troopers.
So notice he said Canton recused themselves from the interview portion. So they didn't recuse themselves from searching for the taillights. They recused themselves from the interview portion, is what he said. And I'm hoping that Lolly asks, since he's asking about, you know, how do you conduct interviews? You do it with a partner. I'm hoping he asks, so is it your standard practice to take notes in these voluntary interviews in the witnesses' homes? No.
From our office in order to conduct those interviews.
And typically, obviously not perfect, but as far as the interviews that you were present for, about how long a period of time generally speaking, were the interviews that you conducted in this case?
From my experience, I have learned that to fully communicate a course of recollection of events that an individual observes, experiences, or is aware of, and understand every detail of that experience, it would take approximately 45 minutes at a minimum to conduct a full interview with a witness in detail.
Biff?
Now, sir, if I could turn your attention to June 9th of 2022. On that date, at some point, did you have occasion to meet with the defendant?
Yes, I did.
And at some point during that meeting, did you have conversation with the defendant?
Yes, I did.
And was that conversation, or at least portions of it, memorialized in any way?
Yes, it was.
Your Honor, may I approach?
Yes.
I'm showing you a disc. Does that contain an audio recording, to the best of your knowledge? Does that contain an audio recording of a court?
I'm absolutely shocked that the Free Karen Reed crowd would manipulate an image. Shocked. And that shock isn't that they're devious like that. It's I'm shocked that they're able to use Photoshop to that extent.
Portion of your conversation with Ms. Reed on June 9th, 2022.
Yes, it does.
Your Honor, may I approach?
Yes.
I'll also seek to introduce the minutes of this meeting.
All right. No objection, Mr. Jackson? All right, folks, before we play this, again, please be mindful of the instruction from yesterday. So you're about to hear statements allegedly made by the defendant, allegedly concerning the crimes with which she's charged in this case. Before you can consider any such statement as evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether the statement made by the defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police or any questioning by the police, the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor, and you must consider the totality of the surrounding circumstances.
Your Honor, with the court's permission, may we publish that for the jury at this time?
Yes, do you want to turn off the air conditioning? Is this very short, right?
It is very short, and if we could, please, yes.
And this is just audio, correct?
You gonna answer the judge?
Okay, you're aware he was speeding up the ramp
Yikes.
We're all on the same joke, right? My taillight is correct and John was pulverized.
My taillight's cracked, pulverized.
Sergeant, on hearing that statement from the defendant, what was your reaction?
Objection.
Sustained.
On hearing that statement, what if any?
His reaction is irrelevant. But my taillight's cracked, pulverized. Now, I wasn't paying enough attention. When was this statement made? Was it a voicemail or was it Trooper Buchanan's recording?
Thing did you do?
I advised the defendant not to further speak.
Objection.
I'll allow that.
Now,
Wait.
at some point,
Wait. The trooper said, hey, stop talking. Exercise your right to remain silent. Such corruption. My God. Such corruption. All right. Good to know. I should pay attention. But yeah, conspiracy, telling her to plead the fifth. What kind of investigator does that?
over the course of your investigation, were you made aware of forensic findings relating to the defendant's tail?
Yes, I was.
And specifically DNA findings?
Yes.
And specifically that there were
Objection.
Sustained. Yes, you can turn the air conditioner.
Okay, that's definitely a pretrial evidentiary ruling. DNA findings? Yes. Specifically, what DNA? Was it John's DNA? Chloe's DNA? Colin's DNA? Her DNA? And by hers, I mean Karen's, not Mrs. O'Keefe, obviously. If it's John's DNA, unless it's just not in evidence yet, you know, calls for facts not in evidence, I don't see how that would be suppressed, because, you know, it's kind of relevant that it's John's DNA.
You are unmuted.
And that's kind of what I'm alluding to. You know, why would they object if it's anyone but John? Because, you know, if it's a dog or Colin or, you know, that devious mastermind Jen McCabe or whoever, they'd be like, oh yeah, let it in. See, they removed the taillight lens and smashed John with it. It was all them. But
Can I have one moment?
Yes.
of course, it could be, you know, I think this is the late submission is actually why it's not allowed, because as I've said, I didn't follow along with the pre-trial very closely, knowing I was planning to stream it. But I do seem to remember there was a fight like right in the last weeks about DNA evidence and late submissions after the deadline for expert exhibits and stuff. And, you know, the sanction for discovery violations is, hey, it doesn't come in. So I think that actually might be what this one is. So, yeah.
So Sergeant Mechanic, on January 16th, 2024, at some point in that day, did you meet with a Sergeant Gallerani of the Needham Police Department?
I did.
And who, if anyone else, well, let me ask you this. As far as any other troopers from your office, who, if anyone else, was there with yourself and Sergeant Gallerani?
Trooper Mike Proctor.
And what was the purpose of your meeting with Sergeant Gallerani and Trooper Proctor on that morning?
Collection of our DNA.
And was that something that you did voluntarily?
Yes.
And how was it that the sergeant collected your DNA?
Through a buccal swab.
Wait,
And
why is the investigator's DNA being swabbed? Unless there's contamination, weren't using gloves or something. Why is Sergeant Buchanan's DNA relevant? This doesn't make sense to me.
were you present when Trooper Proctor submitted to a buccal swab as well?
Yes, I was.
And then as far as the swabbings that were taken from both yourself and Trooper Proctor, were those logged into evidence by you, or did Sergeant Gallerani take them with him when he left?
Sergeant Gallerani took him with it when he left.
And that's it. If there's cross contamination, so multiple profiles, and so this is just elimination to show, yep, wasn't us, that it was already on there, we didn't contaminate it. But this is weird to me. I don't think this is something I've seen before. So,
Madam Mayor, approach.
Yes.
presumably, of course, the reality is his absence of DNA wouldn't be surprising either, because if the taillight struck his arm was covered by it was a light hoodie, but it was still a hoodie. So it's possible that DNA got transferred, that, there's that instant blood or skin cells or whatever. But it's also possible that based on the mechanics of the contact, very brief contact at relatively high velocity through a barrier, the hoodie, could keep his DNA off. I'm not saying it did. I'm just saying if his DNA is not on it, that's not conclusive evidence that he wasn't struck by it. It just, I'm giving a possible explanation that's feasible to me. But once again, I expect his DNA to be on it. So. And there's also that, 3 days of snow melt. What does that wash off? So.
My apologies, Your Honor.
That's okay.
Thank you very much, Sergeant. Your Honor, I have no further questions.
Okay. Cross-examination?
Thank you, Your Honor. Sergeant Butnick, I want to start with one of the latter things that you discussed with Mr. Lally, and that's specific to the ring video.
And may I just make it clear, once again, I dislike little Alan Jackson, and Corrosive makes a very good point as well. CSI is fiction. DNA does not work like it does on CSI. NCIS and SVU, Law and Order, all those shows are fiction. CSI is actually, like, real crime scene investigative techniques are primitive compared to the TV show. So, yeah. Yeah. Well, he's probably influenced by the Turtle Boy Bukkake nonsense. Ugh.
That y'all talked about this morning. Do you have that in mind?
I do.
The search warrant that produced, and just so we're clear, I'm talking about the specific ring video or series of videos that were associated with One Meadows, John O'Keefe's home.
Okay.
Okay. You didn't write the search warrant for those ring videos, did you?
I did not.
You were not the affiant for those search warrants.
I was not.
Who was the author of the search warrant and the affiant?
It was Trooper Mike Proctor.
Who received the actual ring video or videos from the Ring Corporation?
It was Trooper Mike Proctor received it.
And who ultimately either logged those into evidence or controlled those once they were received from the Ring Corporation?
I believe it was Trooper Mike Proctor.
And ultimately, Sergeant Dupick, you did note that in addition to just the physical videos themselves, that login information and login keystrokes, et cetera, were requested from the Ring Corporation as well, correct?
There was discussion with Ring asking for those logs.
I'll call it, is it correct to say an activity log?
That's what was requested, yes, activity log, yes.
So ultimately, the activity log would show who logs in, who accesses the data, things of that nature, correct? Or at least that was the hope.
That is what was requested.
It would also show logging in and executing deletions, manipulating the log files, things of that nature, correct?
That is what was requested, yes.
When you review
So
those,
what Ring needs to do is, for manipulation of Ring videos, they need to activate the computer's camera, take pictures of who deletes the evidence so that they have a record of the evidence tampering. Not that there was evidence tampering, and not that I'm advocating for Ring to invade your privacy, but it would be awfully funny if we had video of Karen Reed. How the fuck do I delete this? Hurry, Dad, help. That would really amuse me.
log or activity logs, there was no evidence revealed that my client ever logged into that account, correct?
There was no activity logs provided by Ring.
So you have zero, hang on.
So this is one of those situations where reasonable inference. Motion activated camera, there's all these other videos, but the one that might be incriminating isn't there. Like, 2 people had access to it. One of them's dead. The reasonable inference is either Ring fucked up or Karen deleted it. So
Isn't it true that Ring contacted Trooper Proctor and indicated that they had created a Dropbox folder that contained the evidence that had been sought in the search warrant?
Objection.
Sustained.
it's hearsay.
Isn't it true that the search warrant return specified account information, video recordings?
So notice the difference. The first question was hearsay because isn't it true that Ring told you this? Hearsay. Did you receive from Ring this evidence? Not hearsay.
And number 3, activity logs associated with video recordings are all times displayed in UTC.
I'm not aware of that, no.
Do you recall that activity logs were in fact provided from the Ring Corporation?
I do not recall that, no.
May I approach briefly?
Yes.
Take a look, Sergeant, at that paragraph with my fingers on it, it's about the 3rd paragraph down the middle of the page, and review that.
Be sure to review the paragraph above and below it too, just so that you have context, because little Alan Jackson is really good at trying to prevent context.
To yourself and let me know when you're finished.
Email absolutely can be hearsay. It's an out-of-court statement, So if you're using it for the truth of the matter asserted, the statement itself, it's hearsay. Of course, if you're given the business records by email, kept in the ordinary course of business, that wouldn't be hearsay. It's just, hearsay is complicated. You'd think he would. But either Sergeant Buchanan is a slow reader or he's reading everything like I suggested. I'm surprised little Alan Jackson is saying, "Aren't you fucking done yet?"
Have you had an opportunity to review that?
Yes.
May I approach, Your Honor?
Yes.
Thank you. Does this refresh your recollection as to?
And see, because he had to give it back, that's why he read the whole thing. Because remember with Jen McCabe, she'd read what he told her to read and then, ask his question. And she's like, well, that's out of context, so I don't know. I think he read the whole thing so that when he hands it back, he knows the full context. So,
To the items received from the Ring Corporation?
That is the first time I saw that document, so it does not refresh my recollection. I simply read it.
So do you have a recollection as you sit here that in fact during the course of your investigation, the three items that you received from the Ring Corporation were the account information, the video recordings, and quote, activity logs associated with the video recordings, all times displayed in UTC?
To the extent of its availability, as it says in that document.
Okay. The long and short of it is, during the entire course of your investigation, you never revealed that investigation never revealed any evidence whatsoever that my client ever even accessed the account information for the Ring account associated with the search warrant, correct?
Nothing provided by Ring proved or suggested or proved any evidence of that type of activity, no.
Thank you. Trooper Proctor, you were notified.
I am not Trooper Proctor.
I'm sorry. No, you're not.
little Alan Jackson really wishes he were Trooper Proctor because he wants to crucify Trooper Proctor. He really wants to try and impeach Trooper Buchanan on the faults of Trooper Proctor. But instead, we get a big oof from a little man.
Sergeant Buchanan.
Sergeant Buchanan.
How do I say it?
Buchanan.
I'll give that a shot.
It's fine.
Buchanan?
Yes,
Is that better?
that's better. Thank you.
If I screwed up again, please. On January 29th, you were notified about a Boston police officer found gravely injured outside the home of 34 Fairview at about 6:40 in the morning. Was that your testimony?
That is not.
What time were you notified?
I was not notified it was a Boston police officer.
So you didn't have that information upon the first notification?
I did not.
Okay, what information did you have?
There was a male party in the snowbank, possibly of a heart attack.
At what point did you learn that the individual was in fact a sworn Boston police officer?
I do not know exactly when I learned that he was a Boston police officer.
I think it was during that day or the following day?
It was most likely that day, either. Yeah.
Fair enough. Trooper Proctor was ultimately assigned as the, what did you call him? Not lead investigator, but case officer?
That's correct.
He was assigned on the 29th, correct?
He was on call from 7 a.m. on January 28th until 7 a.m. on January 29th.
So his assignment was, he was assigned on the 29th because he was on call.
He was on call. His assignment took effect when the schedule came out back in mid-December.
Okay. Well, he wouldn't be assigned to this investigation until there was a need for the investigation, right? That's all I'm getting to. I mean, once the call came in, he was the assigned case agent.
Once the calls come in, the person that's on call is automatically assigned that case.
All right. did you personally, as his supervisor, did you personally respond to 34 Fairview at any point on January 29th?
No, I did not.
Did Trooper Proctor, at your direction or on his own, ever respond to 34 Fairview Road at any time on January 29th?
No, he did not.
Based on your initial investigation, and I'm talking about going way back, Sergeant, on your initial investigation, by 10 or 10:30 in the morning, 10:40 in the morning, it was your belief that Mr. O'Keefe had been struck in the face by a person. That was your initial understanding of the circumstances surrounding the investigation, correct?
My initial understanding was that the defendant stated that she hit him. We did not know them.
Sergeant, you hadn't even met my client at that point. You hadn't interviewed a single
Hey,
witness.
once again, fuck you, let him finish. If I'm Lolly, I'm objecting. Fuck you, let him finish.
By 10:41 in the morning, correct? Not one witness.
That's not correct. We had already interviewed the first responders.
Okay, when I say witness, I'm talking about civilian witnesses. So at 10:41,
Well,
you
well then clarify that, you dunce. When I say witnesses, this is actually what I mean, not those other witnesses that you already interviewed. How the fuck is he supposed to know that, you cretin?
hadn't interviewed a person at 34 Fairview or associated civilians associated with this incident, correct?
At that point, no civilians have been interviewed, no.
But at 10:41, Sergeant, you contacted Good Samaritan Hospital to inform them that, quote, Mr. O'Keefe was struck in the face with a cocktail glass, end quote, correct?
I do not recall contacting Good Samaritan Hospital.
May I approach?
Yes.
She is. Except the trooper hasn't interviewed her yet. Of course, when he says 10 something a.m., is he talking the 29th or the 30th? Because he hasn't been activated at 10 a.m. The state troopers aren't activated, and are they? And or is that certs not activated yet? I'm getting confused, so never mind.
I'd like you to take a look at this document, and if you wouldn't mind, pay special attention to the second page, the bottom paragraph where it's tabbed in pink.
Pretty much. They can't investigate. But that is a good point. He didn't cut him off fast enough. Still, he's not supposed to cut him off mid-sentence unless it's an objection. And frankly, the judge should have admonished him.
Yes.
Thank you, sir. Having reviewed this, does this refresh your recollection that you contacted Good Samaritan Hospital and gave them an assessment, at least based on your investigation at that time?
That is not true.
what did you say to Good Samaritan Hospital?
I never spoke to Good Samaritan Hospital. That document is for the medical examiner's office.
I'm not asking you where the document is from. I'm asking you if the document says Trooper Yuri Buchanan called back at 10:41 stating the case is now being treated as a suspicion.
The objection sustained.
Did you
That's
say,
hearsay, you muppet.
did you call back to Good Samaritan Hospital and say that the investigation was being treated as a suspicious due to a domestic situation? Did you say that?
I never spoke to Good Samaritan Hospital.
Did you say that there's a possibility that D was struck?
He said he called the medical examiner. Is the medical examiner Good Samaritan Hospital?
In the face with a cocktail glass?
Objection.
Sustained.
Did you ever contact anybody at any medical facility and indicate that the investigation was being treated as a suspicious, in quotation marks, because the victim appeared to have been struck in the face by a cocktail glass?
Objection.
Allow that. Did you ever say that?
Yes, Your Honor. Yes, I did say that to the medical examiner's operations desk.
Okay, so when I was asking you if you ever sent it to Sam, you said, no, that's not true. That's never happened. You were correcting me on the.
No, I'm saying she should have admonished Jackson. She should have told Jackson to let him finish. So.
fact that it happened at the medical examiner's office, not at this.
I responded and answered your question honestly, yes.
Okay, so honestly, you did, in fact, at 10:41 a.m. indicate to another professional involved in the investigation that the.
But you asked if he called Good Samaritan Hospital. Different things. You asked about Good Samaritan Hospital. He answered about the medical examiner. Two different things. Two different things. Now, if the medical examiner contacted Good Samaritan and said, hey, Trooper Buchanan has said this, that's different. That's different. Because that's what it sounded like from the start when he said, I didn't create this. This isn't me. This is, the medical examiner contacted them, is what it sounded like. So this isn't Trooper Buchanan, Sergeant Buchanan being dishonest. This is little Alan Jackson getting his panties in a twist because, oh, so you did contact a professional, but that's not what you asked. You asked, did he contact Good Samaritan Hospital? When he contacted the medical examiner.
Circumstance was being treated as a physical assault at that point, correct?
I communicated
Exactly.
our suspicions to the medical examiner's office.
And that was at 10:41 or thereabouts in the morning, correct?
That's correct.
Your initial investigation during those obviously critical hours, the beginning hours, led you to believe that there was at least a good possibility. You indicated that you made a phone call, that it was a physical altercation that led to John O'Keefe's death, correct?
That's correct, yes.
What steps did you take, sir, in those moments, to determine whether someone in the house at 34 Fairview may have been involved in that physical altercation that you suspected at the time?
As investigations develop, we followed the evidence and statements made. The steps I took was Trooper Proctor and I proceeded to an eyewitness who was also present at the scene when the victim was discovered and interviewed Ms. McCabe.
And prior to interviewing Ms. McCabe, by the way, that was at Ms. McCabe's home, correct?
That's correct, yes.
Even though you believe that there may have been a physical altercation, you didn't ask anybody to come down to the station. Is that right? Any of the witnesses?
That's correct.
And you did not seek to actually go to the physical location of 34 Fairview
That's correct.
for the next few days, correct?
Not myself, no.
That's because, now follow me here. He had CERT go to 34 Fairview. Because CERT is the department that conducts searches. Detectives don't do search. CERT, CSI, search and rescue. They do the search. The trooper, the detective, follows the evidence and does interviews and puts it together. Cert does the search. And that's it. To go in the house for a search, no PC. Nothing to lead him there. The search outside the house at 34 Fairview, that was cert. Once again, you know, with the lab geeks. Oh, so someone else did the job and you didn't? How suspicious. How dare you only do your job and not everyone else's job too? Here. So you didn't even bother to go do the search yourself while Cert was doing it himself? How very dare you? Can't believe you. You mean while that poor Cert team was out in the snow searching, you were at the McCabe residence, inside their warm house, conducting an interview, and you didn't even force them to the station to drink the shitty police coffee? You wanted them comfortable? How dare you? Clearly a conspiracy.
As a matter of fact, Trooper Proctor did not either, did he?
No, he did not.
You didn't secure the interior of the house as a potential crime scene. You certainly know how to do that, right?
That's a compound question. Do you want me to answer whether I did it or whether I know how to do it?
Well, I'll ask the question. If you can answer it, please answer it.
Okay.
Can you answer that question?
No, it's a
I can answer
compound
that
question.
question.
Fuck
Why don't you
you.
answer both of them then?
First portion is we did not secure the
Come on, Lolly, get off your ass. Objection, compound.
home as a crime scene. And the second portion, yes, I do know how to do that.
And you didn't, as a Massachusetts State Police official, you didn't secure the outside as a crime scene either, did you?
I did not know.
To your knowledge, nobody else from Massachusetts State Police ever did either, did they?
Yes, they did.
How was that done and when?
When members of our office and the CERT team responded to that location and secured the front yard grass area and processed it.
That was at 5:45, 6 o'clock that night, on the 29th?
I believe it was earlier, but I was not present, so I can't testify to the time.
So you don't know personally what they did to quote unquote secure or not secure the crime scene. You know they searched it, but in terms of securing it as a crime scene, you don't have personal knowledge to that.
I was not present.
You never took any photos of the interior of the house, correct?
I did not know.
You never caused CSSS to go inside the house and process that house as a potential crime scene.
He didn't fucking have probable cause. He didn't have a warrant. You clown. I hope he answers, I didn't have probable cause to enter the house. There was nothing to suggest I needed to search the house.
Correct?
I did not know.
No forensic criminalist at your direction ever went into 34 Fairview.
No, they did not.
Not without probable cause.
And the people that you interviewed on January 29th, you already mentioned Ms. McCabe. The other people were her husband, Matt McCabe, correct?
That's correct.
And her brother-in-law, Brian Albert. Is that right?
That is correct.
And all three of them were interviewed where?
They were interviewed at the McCabe residence.
Now, yesterday when you testified, did you indicate that Brian Albert was not present in the home when you interviewed Matt McCabe and Jennifer McCabe?
He was not present in the dining room when we were interviewing each individual separately.
So if all three of them testified that he arrived before you arrived, they would all be wrong.
I did not see him in the home when we arrived, no.
But his testimony right then and there was he wasn't in the room when we testified, when we interviewed. Oh, so if they say he was there first, they lied? That's a different question. Once again, you know, yesterday Trooper Buchanan did say that Brian Albert arrived after he interviewed Jen McCabe while he was interviewing Matt McCabe. But it's possible hear me out. I know this is crazy. It's possible that's when Trooper Buchanan became aware that he was there. Because I don't know if little Alan Jackson understands this concept, being a lizard and all that, but houses tend to have multiple things called rooms. Now, if Brian Albert were, let's say, in a different room than Trooper Buchanan wouldn't necessarily know that Brian Albert was there. Now, when he finds out that Brian Albert is in fact there, he might, and I know, once again, this human making inferences is unfamiliar to lizards, but Trooper Buchanan, upon learning that Brian Albert is in fact there, might make that inference that, oh, he has just arrived. I know that's wild, but wow.
I want to switch gears real quick to a couple of the physical items that you testified about yesterday, specifically the gray shirt or the gray hoodie and the orange shirt. You and Trooper Proctor collected both of those items you indicated from the floor of the hospital at Good Samaritan, correct?
That's correct.
You testified that you and Trooper Proctor immediately bagged both of those items. They were sort of sopping wet, I think you said.
That's correct.
You indicated that the bags were so wet that you had to take the items back out of the bags and then lay them out on, I think you said, butcher paper. Is that right?
The items were soaked and wet. They were bagged, double bagged, to prevent leakage of physiological.
That's what I got from Jackson's questioning. I don't buy it.
Fluids and the moisture coming off of it. And then once they were transported to the office, they were laid out on butcher paper in order to dry naturally.
So you went from Good Samaritan directly to Dighton, correct?
That is correct.
And then you went from Dighton directly to the Canton Police Department, after which you had seized the vehicle, correct? And the phone.
We seized the phone in the vehicle in Dighton and then followed the tow truck straight to the Canton Police Department.
So at some point, if you had received or gathered the wet clothing at Good Sam, went from Good Sam to Dighton Canton PD, at what point that evening did you finally get those items of clothing out and laid out to dry?
It was late that night, around 10 or so.
So where were the items in the meantime?
They were stored in the back passenger compartment of my pickup truck.
In those double bags?
Correct.
Who took control of the items to then lay them out late that night at the office?
I do not recall.
Is that you or Trooper Proctor?
I don't recall. I don't remember.
At some point, obviously, it's getting late. You've been on duty for a long time that day. You went home at some point, correct?
At some point, yes.
Did you wait for those clothes to dry before you went home, or did you leave that in Trooper Proctor's hands?
No, once they were laid out in the processing area in the office, we went home.
Okay. Who would have controlled those items of evidence when you left?
Well, they're under lock and key within the secure area of the district attorney's office, so they're secured. Nobody's in physical control watching guard over them.
Who had access to that area?
Troopers in our office.
Meaning you, obviously.
Yes.
Trooper Proctor as well, correct?
Yes. Yes.
Ultimately, given the fact that he was the case officer in charge, he would have bagged those items up, been responsible for taking those items.
Oh,
tagging
no.
them.
Trooper Proctor had access to the evidence. Oh.
Getting them stored wherever they need to be stored and processed, correct?
As a case officer, he could direct other people to perform those tasks for him. The evidence officers in the office log in the evidence, and once it was dried.
I think we're on the or what stage, but yeah.
It was sealed up, bagged, and put into storage. As far as who actually performed those tasks, I do not know.
Well, yesterday, Your Honor, may I approach the course, right? There's a couple of evidence.
Oh, sure, go ahead.
Uh-oh. Uh-oh. I hope they have Jackson's lizard DNA because he's handling the evidence bags. Uh-oh.
This is not a vision contest. I'll bring these up to you in just a second, but just for familiarity's sake, do you recognize these two bags as bags that you brought to court with you yesterday?
They look familiar, yes.
Okay. This one has a 437 on it on my right. The one on my left has a 438 on it. May I approach it briefly?
Yes.
Google Fiber is in on it.
I'm not going to ask you to open those. Don't worry about flooding up at this point. The bag on your left, which one is that? 437 or 438?
The bag on my left is 437.
437. Okay. And you indicated that those items were bagged after the clothing was dried and then ultimately processed in, logged in, correct?
Once the items dried, they were bagged and logged in, waiting process. Yes.
But you didn't personally do that.
No, I did not. No.
Matter of fact, looking at the bag on your right, what's been marked as exhibit 430.
It says Trooper Proctor.
438, thank you. That one has some writing on it, correct?
Yes, it has a lot of hand writing on it. Yes.
And that, whose handwriting is that?
I don't know.
You've seen Trooper Proctor's handwriting 1,000 times, I guess, correct?
Not 1,000 times, but
Does it look like his writing?
He has seen it 674 times. Conspiracy.
it says Trooper Proctor on it. But other than that, I do not know what Trooper Proctor's handwriting looks like.
It indicates that Trooper Proctor is the one that bagged that item or those items up, correct?
Yes, this bag indicates that the item was collected by Trooper Proctor on 129.
Right.
At 10.
And it says Brockton, correct?
Don't interrupt.
Good Samaritan Hospital in
you
Brockton, yes.
Muppet.
You just took the question out of my mouth. That's where Good Samaritan Hospital is, correct?
That's correct.
And there's a tab.
Well, no, I was going to make the joke about little Alan Jackson being a graphologist and try and figure out something that sounds similar to graphologist to insult him, but you were saying Trooper Buchanan is a graphologist, so strike that. I won't make an attempt at a crude joke about Trooper Buchanan.
Tag or a printed label, looks like a label maker of some sort that is on that physical bag, correct?
Yes.
Before we get to that, what's the description on that bag in handwriting?
I'm sorry. Can you be specific as to description of what or
Where it says description of items.
description of enclosed evidence?
Correct.
It says 1 orange T-shirt, 1 gray long sleeve shirt.
Okay. So may I approach you on it?
Yes.
Before I do that, just so I close this loop, what's the description on the bag to your left, the one that looks like it's less sprinkled?
Number 437.
Yes, if you would read the same clothing description.
The description of enclosed evidence states sweatshirt with recovered items inside container.
Okay, may I approach now?
Yes.
Thank you. Yesterday when you opened, I'll keep my voice up. Yesterday when you opened these two bags, this one, 437, has the gray sweatshirt in it. 438 has the orange T-shirt in it now, correct?
That's what was in the bag, yes.
All right. However, the bag indicates at one point, this bag, 438, the physical bag I'm holding in my left hand, had both the sweatshirt and the T-shirt together, correct?
That's what the description is. I do not know if that was in case or in fact the case.
It's possible that they were bagged together because they were collected together, but when they were processed, like scraped and shit, they're like, you know what? We better bag these separate. Hopefully that's annotated if it is, chain of custody and all that, but I am shocked that they have the clothing. It was clearly tampered with, and I mean, I know it is shocking that, I try to bring levity when poor Karen Reed, poor hard done Karen Reed is on trial. She's factually innocent, don't you know? Was that Minnesota enough for you, Grey Duck? Don't you know? Boy, when my friend from Minneapolis, I've mentioned before, you know, one of my very close friends from Durham, married a girl from Minnesota. I'm also friends with her. You know, met in Durham, moved to Minnesota. When she and her sister and her sister's boyfriend as well, when they get together and they turn the Minnesota on, boy, yeah, they turn it on. And Grey Duck, I know you know exactly what I mean when I say turn the Minnesota on.
The reason you don't know is because you're not the one that bagged Trooper Proctor did, correct?
The reason I don't know is I wasn't present during the separation of those items, and I did not observe it taking place, nor was I made aware of how the items were separated or when.
You are aware, however, that tag that's on the label maker looking tag, the white tag that's on that bag indicates that indicates a date of February 4th, correct?
You'd have to bring that back up. I'm
sorry.
I didn't take note of that.
My fault. May I, Your Honor?
Yes.
Let's direct your attention to the tag and the associated with that tag.
The label maker tag does have the date February 4th, 2022 on bag number exhibit 438.
May I approach?
Yes.
Yep.
That's obviously 6 days after the item was actually recovered on the 29th, correct?
Yes, it is.
So that indicates, at least based on that tag, that item was not booked into evidence and processed until 6 days after it was actually recovered on the floor at Good Samaritan Hospital. Is that right?
The date indicates February 4th, 2022.
Right. And that date would be indicative, in your experience, of the date that is moved into processing by some other folks, the evidence sergeants or whomever, or the evidence officers rather, or whomever, correct?
I can't speak to their procedures as far as when they print the date. That date could be when they printed the label, but the bag might have been tagged otherwise. I do not know that.
But there's no other tag on that bag that suggests an earlier date, correct?
There's just that one tag from the label maker.
My question to you, if you know, sir, and you may not know, is what was happening to these items between January 29th, after you lost sight of them that night on the butcher paper, and February 4th, when that tag indicates that they were first processed?
To the best of my knowledge, those items were drying on the butcher paper.
For 6 days?
If that's what the label maker says, yes, for 6 days. They were soaking wet.
And those would have been certainly accessible.
They're soaking wet. So here's what Jackson isn't telling the jury. You don't put it in a tumble dryer and say, yeah, it'll be dry in an hour. And you're not, after one day, going to say, well, it's a little damp, but that's dry enough. Let's bag it up. You wait until it's bone dry. Bone dry. Now, in Utah, that might happen in 2 days, 3 days. Boston is not desert like Utah. Like I literally, when I got back from Durham, I posted one day on Facebook that I was missing Durham, and because, you know, it was 105 degrees or something like that. And one of my friends over there was like, ugh. I said, at least it's only 7% humidity. So it's, you know, it could be worse. And he's like, I think you have a typo there. You're missing a number. Is it 70%? Is it 37%? Like 7% humidity didn't process to him. And this is a PhD chemist, you know, real smart guy. But, you know, clothing here might dry out quickly. When I was in Durham, you know, admittedly, Durham is probably on average slightly more humid than Boston, although maybe not. Maybe not. But when I was in Durham, my bath towel, I had to keep it on my radiator, on the heating radiator, because otherwise it would not dry ever. And I don't like mildewy towels. So even in the summer, I'd turn my radiator on in the morning, turn it off at noon. Most days that was fine. It was a kind of appreciated even. But my towel would be mildewy even in the summer if I didn't do that, just because without that heat, it never would have dried because it was humid. So 6 days in Boston in the winter to dry without a tumble dryer, without a, you know, using a hair dryer. Yes. Yes. That makes perfect sense. Because exactly, it has to be bagged perfectly dry. The Commonwealth does not like mildewed evidence. If the evidence were mildewed, the defense would be here. Well, what were you trying to hide? Putting it away wet. Couldn't you have waited another day or two? Would it kill you to wait 6 days to bag it instead of 4? So, armor carrier. Is that like body armor? But yeah.
To, and in the possession of the lead case officer in the case, was Trooper Proctor, right?
Yes, if Trooper Proctor needed to review those items, he would have access to those items. Absolutely.
And you're also aware that the first actual log of any chain of custody for those items is March 14th, when they were finally submitted 6 weeks later to the crime lab.
That is not true. The first actual log of those items is when we collected them from the hospital.
Where's the log? I'm talking about the log, like sign inside. I know that there's a report.
And you work at a hospital, don't you, Grey Duck? At least that's been my impression based on your talk about medical stuff. But, you know, I've often thought, you know, if I ever end up doing family law, I might get one of those, you know, armored vests that are meant to be worn under a dress shirt, just because family law is scary, as we saw in Vegas recently and plenty of other times. You know, I know people who have been in courthouse shootings, and I'm not exactly running away if you get my drift. Like literally, when I got this leg, it's really a fight to get the microprocessor knees, and you have to show a need generally to get insurance to pay for it. Like if liability insurance is paying, you get top of the line. but if health insurance is paying, you've got to fight tooth and nail. And you either have to show you need it for your work, you need it because you're that active or something like that. And I'm like, I'm a lawyer. Shit goes down in court. I need to be able to move quickly. And this, I don't run with this one, but I'm able to move a lot quicker than I was with my first leg. Although that wasn't so much the knee, it was the foot. Because like if I even thought about moving quickly, it would like bottom out, just feel like a dead spot. Whereas this one, as you know, I have it next to me. I'm not wearing it because it's uncomfortable to wear. But you see the foot is basically like a running blade, but with a heel tacked onto the back and a foot shell. The next one I get, I want is similar to this, different brand, but similar, but it doesn't have the foot shell, which I like because I figure you have a robot leg. Why try to mimic human anatomy, especially since the foot shell looks terrible? Who are you trying to fool? Like, what I want is, I want the General Grievous claw. Like, I just think that would be a lot cooler. So, and Biff, what happened in Vegas? So, Vince mentions the guy that Supermaned over the bench at the judge, which is very similar to the courthouse shooting here in Salt Lake I was mentioning at the federal court, where the guy was in the process of Supermaning over the bench to attack a witness, but he was stopped permanently. But the one I was actually referencing wasn't in court. It was in the law firm, in the office, and basically it was a divorce case. So let's say husband, wife, well, ex-husband, ex-wife. New husband was a lawyer representing his new wife, so the divorce was already finalized. This was a custody matter, but the ex-husband, also a lawyer, and father of the ex-husband was also a lawyer representing his son. The ex-wife was terrified of the ex-husband because he'd been making threats. So they were going to have security because it was I believe, a deposition or mediation or something. And they canceled the security because it was revealed the ex-husband wasn't going to be there. So ex-father-in-law representing him shows up and shoots and kills them and himself. Family law is scary. It's scary. You know, it's been described, criminal defense, you're dealing with bad people on their best behavior. Family law, you're dealing with good people on their worst behavior. And this was all like 2 or 3 months ago in Vegas. And others covered it. I didn't, but yeah, it was wild. And Dante, my fellow Utah, there was a guy in Salt Lake. It wasn't in court. it was at the university hospital. He was a prisoner, already convicted, brought to the hospital to um for a MRI, I think, disarmed the sheriff's deputy, I think, shot and killed him, fled, and he was caught at an Arby's on Redwood Road. I think his name was Allgaier. Yeah, Curtis Allgaier. Skinhead tattoos all over his face. Killed corrections officer Steven Anderson. This was back in 2007. So yeah, MRI at the University of Utah Hospital. He'd been complaining of back problems. So he was unshackled because, you know, can't have metal in the MRI. Disarmed and shot Officer Anderson. Fled, carjacked a Ford Explorer. High-speed chase, caught at an Arby's. It says a few miles away, but it was Redwood Road, West Valley-ish area. And tried to shoot an employee at the Arby's, but the gun malfunctioned. And a Vietnam vet, Army paratrooper, disarmed him. And the police caught him in the back of the trial. So not in court, not family law, but yeah, that one was wild. And, you know, near my house, family working at the university hospital, scary shit. Scary shit. It's, yeah.
Anybody can write a report, right? I can write a report. Doesn't mean anything. I'm asking for a log.
Objection.
So the objection sustained.
It's argumentative. Fuck
Obviously,
you.
when items move in and out of people's custody in an official capacity for the Massachusetts State Police, there's a log of that, correct?
It's documented. Yes,
Or at least it should be, correct?
it's documented.
Where's the log of these items before March 14th?
It's documented in the report.
There is no log, is there, Sergeant?
I do not know.
I want to talk a little bit about some searches that Mr. Lally asked you about, February 4th and February 10th, very specifically. Both of those searches you were involved with out at 34 Fairview, correct?
Correct.
But Sergeant, you didn't personally write a report about your conduct at 34 Fairview on either of those 2 dates. In other words, you didn't go back to the station and generate a report yourself.
I don't recall doing that now.
There were no photos that you took of the items at the location.
I did,
Poster photos, correct?
I did not take photos of the items.
Holy cow. Once again, you didn't duplicate efforts. How dare you? How dare you? How dare you? Everyone on scene should do everything, and no one should do anything. That's the little Alan Jackson theory of detecting. Everyone should do everything and no one should do anything. Otherwise, it's a conspiracy. Division of labor, out. Because that's a conspiracy. that's a conspiracy. It's, you know, we didn't hear it from the sergeant here, but one of the previous, I believe it was way back when the Canton police spoke, and Jackson and Yannetti, oh, so you didn't write a report? You didn't summarize the scene? Da 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 da. And they answered, we don't all write reports about the search. We do the one report, and that's going to be the lead. So presumably the report of the search would have been Trooper Proctor or the CERT commander. Can't remember his name. He would have done it, possibly. Trooper Buchanan, Sergeant Buchanan, doesn't have to duplicate those efforts. He can write his own report, but he doesn't have to. Because once again, as long as someone does it, and the right person does it, you know, it's not a conspiracy that not everyone writes a duplication of the report. As far as the photos, yeah, you're going to have one person with a SLR camera, you know, a Nikon, not an iPhone, taking the pictures. Why would Trooper Buchanan, Sergeant Buchanan, have the SLR? Why would he have the Nikon? You'd have the photographer have the Nikon and take the picture. But if you have a division of labor, if you have people do their jobs and not their coworkers' jobs, that's a conspiracy. That's what's suspicious.
Okay. And the first report that indicates anything that happened or was recovered at the location on either February 4th or February 10th, that was first notated in a report dated November 4th, 2023, year and several months later, correct?
If you say so, I do not know the exact date. That report would have to be presented to me.
May I approach?
Yes.
You don't have to read the whole thing, but if you can skip to the part.
No,
that talks about
read
February
the
4th
whole
and February
thing.
10th searches.
Read the whole thing. Just don't fall for his trick.
I'm sorry, I didn't realize you're finished already. What's the date of that? Well, let me ask a foundational question. Does that refresh your recollection as to the date of the report that actually talks about the February 4th and February 10th searches?
It does.
And what's the date of that report, sir?
This report is dated November 4th, 2023.
Thank you. May I approach?
Yes.
Thank you. Now, as it relates to those two searches, I'd like to ask you a little bit about the February 4th search first. You indicated that you actually responded to 34 Fairview personally, correct?
I was responding to that location on my own. I personally responded, yes.
Okay. Something or found something. Is that right? Chief Berkowitz from Canton PD.
That is not correct, no.
Okay. So when you got there, was Chief Berkowitz there?
Yes, he was.
You just happened to go by 34 Fairview at the exact same time on the exact same date as Chief Berkowitz, or was that coordinated in some way?
There was no coordination between me and Chief Berkowitz. As I testified, I had directed the troopers to go by the location. I planned to go by the location in the morning on the way to the office and in the afternoon on the way home, just to see if any more items would reveal themselves. So that morning, I was actually traveling to that location in order to conduct a view of the area to see if any more evidence had been revealed. Prior to my arrival, approximately while I was on chat.
I'm absolutely shocked that Jackson didn't butt in here, that he didn't interrupt. I'm absolutely shocked.
Chapman Street, I received a call indicating that Chief Berkowitz was at the location, yes.
And was there also an Officer Lank, Sergeant Lank?
I do not know if Sergeant Lank was there, no.
Chief Berkowitz certainly was there,
Yes,
and Chief Berkowitz indicated that as he was driving by, he saw a piece of glass
yes.
and stopped his car and then started making phone calls.
I believe that's what he indicated to the caller, yes.
Did you question Chief Berkowitz about why he was driving by the location in the first place?
Absolutely not.
Okay, you knew at that point that the Canton Police Department had been recused because of at least an appearance or potential for a conflict of interest.
He said earlier they were recused from interviews, and it was voluntarily. But
Correct?
I knew they recused themselves due to only in respect to interviews. They didn't want to conduct interviews with us side by side.
If there's conflict of interest, Sergeant, for the department, conducting the interviews is just one aspect of an investigation, correct?
I'm not going to speak like a conflict of interest, but yes, conducting an interview is just one aspect of the investigation, yes.
So is it your testimony that your understanding was they couldn't conduct interviews, but they could collect evidence, store evidence, write search warrants, get returns on search warrants, execute search warrants, conduct searches? They could do all that and not conduct interviews?
My understanding was they were recusing themselves from conducting interviews. They still allowed us to use their facilities. We utilized their conference room to conduct interviews. There was evidence being stored at their Sally Port, being the vehicle. So that was my understanding.
Isn't it true that you knew that the entirety of the Canton Police Department had recused itself because of a familiarity between one of their members, Kevin Albert, and the Albert family on whose lawn John O'Keefe was found? That was the conflict, correct?
I knew that was the connection between them, yes.
And you understood, sir, that that agency was to have nothing from an investigative standpoint, nothing to do with this investigation, correct?
They were not conducting the investigation, no.
Matter of fact, Trooper Proctor and you supervising him, y'all were conducting the investigation, right?
Our office was conducting the investigation.
So did you find it unusual?
and their office is who had jurisdiction to conduct the investigation.
Or suspicious in any way that the chief of police for the conflicted Canton PD was the person driving by 34 Fairview looking for evidence?
Objection.
Can you answer that question, Sergeant?
He would have to repeat it. There's just so much I can't.
It was a little wordy. I'll try again. Did you find that suspicious?
Which part? You have to repeat the whole thing.
That Chief Berkowitz from the conflicted Canton PD was at 34 Fairview looking for evidence?
The way you posed the question, I did not find it suspicious at all. He's the chief of the police in the town where he works, and he's driving down the street. I mean, that's not suspicious.
With a conflict of interest on the very case that he's driving by.
Objection.
Sustained.
Fuck you. Repeat after me. Fuck you, Alan Jackson. Stop with the commentary. That wasn't a question. With the conflict of interest. Fuck you. Stop with the commentary. It's time for the judge to admonish him again. Mr. Jackson, we've talked about this. Shut the fuck up. A conflict of interest is a legal conclusion, whether or not there is a legal conflict of interest. Now, for the Canton police to say, yes, we're going to recuse ourselves from conducting interviews, that's for them to decide. Now, did they have to recuse themselves? Maybe. Maybe not. I don't know. I don't know where the line is. Was it a good idea for them to recuse themselves? Yes. Of course. Once again, the reason I would have recused if I were them is because, you don't want Canton police to be interviewing the Alberts. But there's no evidence that the Alberts were involved. So searching the scene, I really don't see a conflict. Now, you know, is it a close call? Maybe. But searching the scene on and near the road outside a Boston police officer's house, obviously Kevin Albert shouldn't have anything to do with it. But, and especially you're driving by and you see evidence. Now, Chief Berkowitz probably shouldn't be processing that evidence, but he's driving by and he sees evidence. Hey, call it in and say, hey, I think I found evidence, and then stand guard over it until the state police arrives to process it. Not only is that not suspicious, but that's probably the proper thing to do, as opposed to driving by and ignoring it. It's like, drive by. Oh, there's some evidence, but we've recused ourselves from conducting interviews. Better not even mention it. I hope they find it on their own. Well, that would be dumb. Or, wait for Brian Albert to mow the lawn in April and say, oh, hey, I just found some evidence. Time to call the Stadies and have them come process it.
You certainly knew, as a supervisor over the case officer, that any involvement by Canton Police Department, given the fact that there's a potential conflict, any involvement by them could compromise your otherwise clean investigation. You knew that, right?
Not necessarily, no.
Did Chief Berkowitz disclose to you that morning on February 4th that he had been communicating with Brian Higgins and Brian Albert, two witnesses, on your case that morning?
Objection.
Sustained.
That's hearsay.
If you knew information about communication between and among Canton PD and your witnesses, you would find that inappropriate, would you not?
Objection.
Sustained.
You returned to the scene on February 10th, is that right? To conduct another search, you said.
I was present on the 10th, yes.
Who dispatched you back to, or did anybody dispatch you back to that location on February 10th? How did you end up there is a better way to ask it.
February 10th, just like previous days, we made plans to go to the location in the morning and the afternoon, drive by. I was on my way to work and to home. So I traveled that route on purpose. And as evidence revealed itself due to the natural melting of the snow, we would stop and collect the visible evidence.
You believe at this point, sir, that whatever you might collect at the scene would obviously be important, correct?
Anything we collected that had evidentiary value or presented itself as somehow related to the crime or the incident would be collected.
And it would be important to the investigation, right? You treat it as important.
It is a point, yes.
So my question is, especially as it relates to the February 10th search, where there were multiple items found, did you seek to have CSSS come out and actually either mark with GPS coordinates or measure with cross coordinates exactly where each item of evidence was found?
We did not do that. We had collected so much evidence already, and so much has been documented at that point that we did not contact crime scene services to come back out and photograph more shards of glass and plastic. We simply collected it for processing.
So the location of each one of those items was not of that great importance to you, at least at that time?
It was of great importance as to the fact that it was located in the vicinity where the victim was found and in the vicinity of other items located of the same characteristic, shape, size, and color.
It's my understanding, though, William, is it's the judge's order that if you have to state the grounds for the objection, you've got to approach. And most of the time it's obvious, yeah, that's hearsay. And yeah, it's at the same time, it is kind of annoying, the constant bench trials instead of a simple objection, hearsay, and be done with it. But as far as GPS, once again, the location of each individual piece in relation to other pieces, the reality is that doesn't really matter. It's the general location is what does matter. You know, if you're finding it over on the other side of the driveway, that matters. But if you're finding it all, frankly, within the margin of error for the GPS, at some point you stop with the GPS because it's just redundant. It's noise, is what it is. Because the reason you want to know the location of the taillight fragments is because it tells you the general location of where it was broken. Now, having, oh, well, this shard was here and this other one was here, and therefore the exact location of the impact was here, isn't going to happen. It doesn't work that way. This isn't CSI. This isn't CSI. And so that's it. The, 10 to 16 feet in best circumstances, why would you mark, yeah, this was found exactly 16 inches from this? But that's 1/12 of the margin of error. So, yeah. You're not going to worry about that. So, they might. It'll be a waste of money for them, I think, but they might. I don't know. I doubt it. An accident reconstructionist. But once again, an accident reconstructionist isn't going to show, well, if the crash happened like this, it would cause the glass to break in exactly this fashion, and each piece is going to break in, fly exactly this far and in this direction, and yada, yada, yada. And it's just all nonsense. Every bit of it. And what you missed is little Alan Jackson being a pedantic little lizard and annoying me. So that's what you missed.
So that's my question. What does vicinity mean?
In the area.
Okay, what does area mean?
Fuck you.
It's a location, specific location.
Okay, are we talking about, 'cause we do this all day, I guess, are we talking about an area of 5 feet or an area of 50 feet?
Fuck you. Fuck you. We can do this all day. Ask better questions then. You want to know what an area is? Consult Merriam-Webster. Stop with the comments. Fuck you.
Based on where the items were recovered, we're talking about an area approximately of 30 square feet between the
So
roadway
5 feet by 6 feet?
into the grass. It's the
We saw photographs, Sergeant, of items that were butted up against a fire hydrant, in one instance, correct? Yes?
That's correct, yes.
A drinking straw that's out in the road, correct?
That's correct.
Another shard of glass that's in the grass, closer to the flagpole, correct?
Correct.
A hat that's under the snow, adjacent to the left side of the flagpole, correct? I'm sorry. It wasn't. It was closer to the electrical box, wasn't it?
No, the pictures that documented where the hat was.
It's
to the
called
right.
a bench slap, Brandon. A bench slap. But yes, he absolutely needs a bench slap.
The flagpole.
So these shards of glass, the point I'm asking is, did you seek to use basic cross coordinates, measurements from something that you know is a known object, like for instance, I don't know, a flagpole or a fire hydrant? 27 inches to the north and a foot and a half to the south are those two known points. That would give you a cross coordinate, correct?
It would document the exact location, correct?
And you did not do that with any of these items, correct? Correct?
The items that were not.
And once again, So you conducted a completely normal investigation, correct? How suspicious. How very suspicious that you didn't conduct your investigation the way I wanted you to. You just did it the normal way. How dare you? How dare you? And they shouldn't. They shouldn't, but the judge is really letting Jackson get away with it a lot. The snide comments she has, most of the time, because she doesn't want to prejudice the jury on anything. That's the reason for all of the bench conferences. But we know she's chastised him at those bench conferences because the few times she has admonished him in front of the jury, it's been, Mr. Jackson, we've talked about this, stop. So you know it was more severe outside the presence of the jury. But at some point, she needs to put some teeth in this. Mr. Jackson, next time it's contempt and $1,000. But yeah, and William Graber asks a very good point. If they had done exact measurements, what would it change? Nothing. Absolutely nothing. Because once again, you can't do, this isn't CSI, knowing the exact locations isn't going to give you the exact mechanics of how it broke and because we don't know, you're not going to run a simulation and say, oh, well, yeah, this is exactly how the glass would have shattered. That confirms it. That doesn't exist. It's, the expected spray, basically, not the expected location that each piece would land. And it's ridiculous. But when you've got nothing, whatever. Ugh. And I need to catch up on that, but yeah.
Not photographed, were not also GPS located, but they were within the same vicinity of where the other items were collected.
But again, now we're back to the same question. Your word for vicinity might be different than my word for vicinity.
Well,
right?
fuck you then.
Sustain.
Fuck you. Stop. That's argumentative. You get the answer you get. Don't argue.
When you recover these items, or any other items, it's obviously important to memorialize on the evidence bag or in some other way exactly where they're found, who found them, the date, time, etc. Correct?
We do the best we can to document all known information on each evidence item bagged at the time.
And in terms of the February 10th search, I want to just ask you a couple of quick questions about that evidence bag. Did you bag the items into a single evidence bag that you found that day, or do you recall?
I would have to see the bag. If you have those available, I'll take a look. I can answer.
Of course, permission. Exhibit, I think it's 310. It was entered into evidence yesterday. I'd like to display that for a second.
Okay.
You're looking at a photograph of what was previously entered into evidence as 310. Can you see that from where you're at? I don't have the evidence bag with me, so if you don't, I can certainly ask the space to enlarge it.
If you can enlarge it, please.
Just portion to the right. Madam Mayor, approach.
Yes.
I didn't realize I've got a photograph of it.
Can you need the lights on, Sergeant?
Please. Thank you.
Should make it easier. Sergeant, have you been able to familiarize yourself with that evidence bag?
Oh, with the photograph, yes.
Okay, thank you. Taking a look at that evidence bag, it has the information on it, has your name is collected by, correct?
Correct.
The date of collection is February 10th, is that right?
That's what it says, yes.
Okay. And it indicates multiple pieces of red, black, and clear plastic, right? It actually says 6 pieces of red, black, and clear plastic, correct?
That's correct.
That is,
COVID DV calls are scary. I hate defending DV cases. They're such a pain.
not an evidence bag was filled out by you.
I did not fill that bag out, no.
Matter of fact, that's Trooper Proctor's handwriting,
I do not know what Trooper Proctor's handwriting is. I cannot confirm that that's his handwriting.
but it's not your handwriting.
It is not my handwriting, no.
So are you aware that this particular bag, that bag that contained those 6 items of plastic material that you already deemed was incredibly important to the investigation, was never going into any evidence until March 14th, the date that it was submitted to the crime lab?
I was not aware of that, no.
We can take that down, please. If I may approach, Your Honor?
Yes.
Thank you.
You're welcome.
Did you ever draft a report yourself documenting the recovery of those 6 items and the other 14 items that you said that you found on the same date, February 10th?
I did not, no.
Did you leave that assuming that Trooper Proctor would document that?
Objection.
Sustained. Ask it differently.
I'll ask it another way if I can. Did you believe that you didn't need to write a report, Sergeant, because Trooper Proctor would take care of that?
I knew that it would be documented. It was already documented on the actual bag as far as who collected it, when, where, what it was, and a report eventually would be authored on it.
But the where, for all these very intricate pieces, the where is left to,
He didn't drop what he was doing to write the report. He just relied on the evidence. You know, Jackson is hung up on the report, but the report is to summarize. So what you do is you document it. Now, documenting it would be in writing. It would be, you know, the labeling the evidence and stuff. I found this here. That's not the report, though. That's done later. You don't drop what you're doing and write the report. That would be stupid. You just document it so that when the report is written, you can use what you documented to write the report. Suspicious.
34 area on that, correct? Is
Objection.
I'll allow it.
that right?
The general vicinity location of the other items collected and documented with photographs was consistent with the same locations this was collected.
I want to shift gears for just a second. Well, actually, I want to ask one final question about that item. Based on the documentation that you just mentioned, that it's documented on the bag, and if the bag is presented to the crime lab on on March 14th, some 5 weeks later, those items were completely unaccounted for from a log standpoint for the entire time from when they were collected until they were booked at the crime lab, correct?
Objection.
Sustained. Ask it differently.
Possession of those items, of those 4, 5, 6 pieces.
Are you talking about the items that were just displayed on the screen?
I answer.
I did not.
Now I'd like to shift gears to a ring video that you saw yesterday. It's in Exhibit 6, video number 153. That may mean nothing to you. It's the 5:07 a.m. video of the Reed's car pulling out of the One Meadows garage. Do you remember that video?
I do.
Okay. You indicated yesterday on questioning, under questioning by Mr.
Hi,
Lowry
Verdan.
that
Good to see you.
Miss Reed's car came in contact with or close to coming in contact with the other vehicle, the Traverse, in the video. Is that right?
What?
The video, as I watched the video, I observed the vehicle come near Mr. O'Keefe's car.
Okay, that's what I want to talk about. With the court permission, may we play that video one more time. Maybe you can pull that up and then I'm gonna ask you to pause it and get out of the way.
There is an evidence or a witness list. I haven't seen it, so I can't tell you. But of course, just because this doesn't mean they are obligated to call them as a witness.
Okay, can you just play that for a quick second? No, I'll pause. Pause. Does that appear to be, I'm just pausing it in the first 2 or 3 seconds. Does that appear to be the video that you saw yesterday?
It appears that way, yes.
Okay. Mr. Bates, if you could enlarge the area around the the left rear tire of the Traverse. I'm going to ask you, sir, if you'll pay close attention to what's been zoomed, and when the SUV gets close to it, I'm going to pause and ask another question. Can you go ahead and play this?
Your Honor, I'm going to object to this.
So why don't we pause the screen, take it down, and I'll see you at sidebar.
Let's see. I'm going to. How long is this? Right there.
I'm going to try to situate myself when I'm out of the way. If we can have the lights, then Your Honor.
Sure.
I appreciate it. Thank you.
Okay, go ahead and enlarge the rear area of the Traverse. And I'm going to ask you to pay special attention to the back wheel and any movement that you may or may not see. Pause it. In about the next 3 seconds, starts with I'm asking you to pay attention to it. Go ahead. Okay. We can have the lights on. And you can take that down. Sergeant, were you able to see that video?
Okay, I did see the wheel wobble a little bit, so.
I know it's the first thing in the world. Were you able to see that video okay?
Yes.
What did you notice about the rear wheel of the Traverse?
Based on the motion in the shot with the snow falling, it appears that there is movement, but the video speaks for itself.
What would you assess based on the movement of the rear wheel of the Traverse about whether or not the two vehicles came in contact with one another?
Objection.
Sustained.
That's speculation.
Okay, I have just a moment, Your Honor. Yes.
Double jeopardy for DMA. How the fuck would that be double jeopardy? But yeah. Zoom in on the lack of glass, why don't you, Mr. Jackson? I mean, if we're zooming in, that's what Lolly should do, is on redirect, zoom in and show, do you see any taillight fragments after she drives away? No? Oh. And also, she bumped his car on purpose to evidence tampering. Let's zoom in on the windshield. Let's zoom in on the windshield and see, is she doing something to override the backup alert, the auto stop? Let's zoom in on that, shall we?
May I inquire?
Yes.
Thank you. I'm trying to use my time wisely, Your Honor. Yesterday, Sergeant, you were asked about a couple of videos related to the Sallyport garage. Do you have that in mind?
Yes.
Matter of fact, we watched one of them pretty specifically toward the end of the day yesterday.
And the report is that the Lexus actually has the auto stop collision avoidance. So, you know, you have to take affirmative steps to back into something, generally. Now, whether the blizzard plays an impact on that or not, I don't know. But yeah.
Did you actually, I want to talk about the one that is the clearer of the two, where you slip. You remember that one?
If you pull it up, I can.
I will in just a second.
Okay.
There was one where Mr. Riley paused it and you were slipping in front of the vehicle.
I don't recall myself slipping, no, but it was icy that day. So if there's documentation of me slipping,
Fair enough. I didn't mean anything by that other than that was a moment that I thought you might recall to differentiate the videos. It's exhibit 446, but I don't think that's going to help you. All right, let's see if I can do this another way. Did you actually personally go to Canton PD to retrieve any or all of the videos of the Sallyport? You yourself?
I did go to Canton and collect already extracted video,
Okay.
but it was a portion of video surveillance. I didn't collect all of the video, so
When was the most recent time that you went to Canton to collect a portion of the video?
I don't remember.
Okay.
I don't remember. I'm sorry.
Did you review the?
And that's also possible. It's of course the flying snow, and this is just me speculating. I honestly don't know. Is it the backup camera, or is it proximity sensor? I don't know.
Well, let me ask it this way. Did you collect the video that was sought on or about April 23rd or 24th this year? In just a few weeks ago?
Did I collect it?
Correct.
I did not collect that video of April this year. No.
You're aware that the video that you saw yesterday was in fact collected after the trial started in April of 2024?
Objection.
Sustained.
Are you aware of when that video that we saw yesterday was collected?
Objection.
Oh,
I am not aware.
Okay. Was yesterday the first time you've seen that video?
No.
When had you seen that video previously?
A couple of weeks ago.
Okay. What were the circumstances in which you saw that video?
Objection.
sustained.
Did you have a meeting with the DA?
Objection.
Sustained.
That's inquiring about the DA's work product privilege.
Did you ever have any kind of communication with Mr. Lally about your testimony?
Objection.
Sustained.
May we approach?
Yes.
It's, asking about his conversations with Mr. Lally are, the DA's work product privilege. So, just saying objection, it's clear to me. It should be clear to the judge as well, because frankly, she should know better than I do. But yeah. But so, did Mr. Lally tell you how to testify about this video? Getting annoyed by the defense. Let's see. Can I do custom? Yeah. I'm going to 1.35 speed because I can.
Yes.
Thank you. Sergeant, did you have any meetings or communications with Mr. Lally in anticipation of your testimony?
Yes.
Hey, he sounds even more chipmunky at 1 1/3 speed than 1 quarter.
When was that?
It was about 2 weeks ago. And then
Don't forget Rome and the Roman Empire, because Julius Caesar, the Canadians, because of Russian trees and leaves, and everyone is in on it.
last week, I believe.
And what was discussed? Generally.
Generally, we discussed the portions of the case that I would be presenting.
Did you write a report about your communications with Mr. Lally?
No, I did not.
Why would he? Why would he write a report about that? What? Honestly, why would he? Yeah, let me just, make a report so that, they can maybe find it and breach the attorney-client, attorney work product privilege. Why would he? Why would he? But very suspicious that you don't write a report about fucking everything. Why would he write a report? That's stupid. That is stupid. I think so. I mean, Kevin Mahoney, I think, said he hasn't tried a case in front of this judge. Not sure if he said he's appeared in front of the judge, but said he hasn't tried a case, but he knows people and says this isn't like her. So it annoys me that, don't change. Don't change your standard practices just because a case is controversial or high profile or whatever. So work product privilege is, as an attorney, my notes, my conversations with witnesses, my preparations are my work product, and they're privileged, just like attorney-client privilege. So my client's conversations with me are privileged, but my conversations with witnesses. Now, it's not attorney-client privilege, so there are ways to get what they said in potentially. The evidence they disclosed to me isn't privileged off of attorney-client privilege, but my discussion with them is privileged because it's my work product. So you can't make me testify about it. You can't make me disclose it, but you can't make them testify about it either, necessarily. There are exceptions. This is the very generalized, but yeah.
Were you shown any of the videos that you've seen here in anticipation of your testimony?
Not during the first meeting. I did review a video during the second time.
Okay, and that video was that you did see the second time was the interior video of the Sally Port that we saw yesterday, correct?
I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meeting, so I don't remember exactly what video Mr. Lally showed me.
But you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You have seen that one before?
Yes.
And that was with Mr. Lally, correct?
That is not correct, because I do not recall when I saw that video or what video I saw with Mr. Lally.
I see. All right. I'd like to talk about that exhibit 446 for a second, and then I'll show it to you. You indicated that the video that everything that you saw yesterday was true and accurate, correct? Based on your memory of the events that were memorialized in the video?
The video captures events taking place in accurate fashion, yes.
In an accurate fashion. All right, that's what I wanted to find out. And after you watched the video, I think you were asked by Mr. Lally, does the video show you or Trooper Proctor having access to or messing with in any way that right rear tail light in any fashion? And you said never.
I was asked if at any point Trooper Proctor and I had came into contact, I believe, or touched the vehicle in that portion of the vehicle, and I said never. We never touched the vehicle prior to it being properly processed with a search warrant.
And that was specifically his question was to, and your answer was to the right rear portion, right? That right rear tail light.
The right rear damaged taillight, correct.
With the court's permission, I'd like to play a portion of Exhibit 446.
Okay.
Before we begin playing it, Mr. Bates, if you wouldn't mind.
Maybe, but like they removed the taillight housing. That's messing with it, but it's for evidentiary purposes. They, fit the pieces together, the broken pieces, and, fit them to the taillight. That's messing with it, but that's evidentiary. That's not tampering. If they document it, they take pictures and say, this is what the taillight is like. There's the broken lens piece hanging by a thread. We are removing it for safekeeping and labeling it as, piece 47A in this bag. This is how we found it. This is how we're storing it. That's messing with it, but it's not evidence tampering because it's processing the evidence. So, what's messing with it is the question. So, and that's it. Is it, is there the intent to obstruct, or is it the intent to document, to preserve? Because tampering would be trying to obscure or destroy evidence. Whereas, like, even if they remove the taillight, as long as they document it as they deconstruct it for evidentiary purposes, that's fine. In fact, it's more than fine. It's the process you have to go through. So, yeah.
Inquire, Your Honor, of the witness display foundation. Sir, did you recognize this as being the video that you saw yesterday?
It does look accurate.
Okay.
Yes.
I just want to make sure we're on the same page. This is 446, just so you have it in mind if I reference that. So you can play that. And I think it's runtime 120.
And Jim Short makes a good point. They were already finding fragments at 34 Fairview when this is
Do you recognize
happening.
that as the video we saw yesterday?
Yes, I do.
And another good point. How very dare they? And Grey Duck also makes a good point.
Time of day, 5:37:05.
Oh, no. Wait. I was going to make the joke. Oh, no, it's fast forwarded. Conspiracy. But I have it on 1 1/3 speed, so never mind.
Yes. Court's permission, can we play this one?
Yes.
All right, that shows the vehicle coming into the Sally Port, and we're looking at which side of the vehicle?
So that is the driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate representation of what you're seeing, it's just inverted. So that is the driver's side of the vehicle. I do not know why It is inverted, but that's the way it was presented, collected and presented from Canton Police.
Can you see a timestamp or a time and date stamp on the bottom of that? It's in blue.
I cannot know.
Does it appear that time and date stamp, if you can't read
And why did they play it in reverse? Re-spreading the snow into the garage. Why did they play it in reverse?
every letter on it, that is in correct order? In other words, that's not inverted.
I cannot read it, no.
All right, let's go and play this for a second. Who was that just got out of the car?
I do not know. I think that's the tow truck driver. He would have the only access to the vehicle. We did not touch the vehicle.
Who's that on the left?
I missed that. I was looking down at the laser pointer. I do not know. I know for a fact, I'm the gentleman that's wearing a dark olive drab state police baseball style hat, and Trooper Mike Proctor is wearing a winter hat.
Trooper Proctor's wearing what?
A winter hat.
Back that up, just
That is my understanding. It would be nice if Lolly had pointed that out yesterday, but yeah, conspiracy.
that was playing, and I didn't realize it was playing while you were talking.
Look at them all walking backwards and
Do it from that. And stop. Yesterday, when you testified, you indicated that the two individuals in this scene were you and Trooper Proctor, correct?
Not correct. There was two individuals in the rear of the vehicle. I shined my light to. That was me and Trooper Proctor.
You see Trooper Proctor toward the back of the rear of the vehicle there?
I can't tell because of what the head is. I just know that Trooper Proctor was wearing a black hat.
It's the person in that in the video to the left, to the rear of the car is wearing a black hat, correct?
I can't tell. I don't want to be locked into a statement where later on you show me that it's somebody else magically. I can't testify to that.
There's no magic about this. It's your testimony. It's
fuck
exactly what
you.
see.
I don't see that. No.
So, let's go ahead and play it this way. Do you see the person toward the back of the vehicle walking toward the opposite side of the SUV?
I do.
What area does he appear to go into?
He appears to be going towards the rear passenger side of the vehicle, although it does not appear so because the video is inverted, a mirror image. That's where he's going.
And Sergeant Buchnick, you testified for at least a half an hour about this video yesterday, correct?
I'm sorry, it was a long day. I don't know the timing of how long I testified.
You significantly testified about this video yesterday, did you not?
I testified about this video.
And you testified that it was true and accurate, correct?
Correct.
You testified that it was it was reflective of your observations of what was happening in that Sally Port that evening, correct?
I testified that this is a accurate scene and collection of video evidence from the Sally Port.
And as that truck sits in that Sally Port, just like this, it appears from all perspectives that what we're looking at is the passenger side of the car, and that right rear taillight is right there shining in our face, correct? From this perspective.
CJ5?
I'm sorry, can you repeat the question?
From this perspective, from the perspective that the jurors are looking at,
Okay.
from all indications, that would appear to be the right side of the truck, the passenger side of the truck, and that taillight that you can see is the right rear taillight from this perspective, correct?
The way it presents itself, yes.
And yesterday, during the entirety of your question by Mr. Lau, not once did you mention that this video is actually completely inverted.
I did not know.
Mr. Lally didn't ask you if it was inverted, correct?
That's correct.
And if I hadn't gotten up here and begun questioning you, that would be left uncorrected, correct?
Objection.
Sustained.
The person with the winter cap appears to walk directly to the what ultimately should be the right rear taillight of this car, correct?
That's the vicinity, yes. That's where he's in.
Pause it. I'd like you to pay attention to the right rear of this car. And I know we're completely backward, but it's the far corner of the car. Do you see a person's head there?
It appears as if someone's still there.
And that person is located at or near what portion of the car?
In real life or as it's depicted?
Is the person near the in real life near the right rear tail light of the car?
Yes.
Okay, standing there, hovering around there, correct?
We don't know the distance that they are in proximity to the actual vehicle. We just know they're behind the vehicle. That
Looks like it's pretty close, doesn't it? Sorry.
Objection.
Sustained.
Does that look like he's in close proximity to the right rear tail light?
As I said, I can't tell how far away he is from the vehicle.
It's right there, sir.
Fuck you.
You can't tell he's right next
Fuck
to the right rear
you,
tail light?
fuck you, fuck you. Stop with the commentary, Jackson. Ask questions. Ask questions. Time for the judge to say again. Reminder for the jury, Mr. Jackson's outbursts are not evidence. Only the witness testimony is evidence.
Objection.
Sustained.
I want you to pay attention to what that person does as soon as the other person comes out from behind that car. So you see him move.
That's it. That's why she needs to chastise him in front of the jury.
I saw movement in the frame, yes.
She needs to sanction him. You know, getting ticked off at the bench conference, whoopee, who cares?
Right when the other person is in eyesight of the person toward the right rear, correct?
I mean, the video speaks for itself.
Yeah, it does.
Fuck you.
Objection, Your Honor.
The objection sustained. No commenting, Mr. Jackson. We've talked about that.
I'm going to ask Mr. Bates to back it up because there's one other issue I want you to pay attention to, if you can, right at this moment or right before this moment, and that is the timestamp. You back it up in maybe 10 seconds. Right about there. Don't play yet. Instead of paying attention to the individuals, and ask you, can you see, and it puts the screen on this, can you see the timestamp at 5:37 and 37 seconds PM? Can you see that from where you're at?
No, I cannot.
Me neither. But I don't know, that's okay.
Fuck you. Stop with the commentary. Stop.
Play it for about 10 seconds. Pause it. Did you see another person just appear toward the big rear end of the car?
There was a fog of some sorts. It did appear as if a person was actually in, there was two people back there and two people walked away, or one person walked away.
Timestamp
There's a door right there.
5:38:01. Correct?
I cannot see the timestamp, sir.
Did it appear that there was an anomaly? There was a portion of that video that was deleted. It's missing, not deleted, but just missing.
Objection.
Can you tell that? Does it appear that way to you, Sergeant?
No, Your Honor, I cannot tell what is happening with the video.
If you take a look, a close look at there's a classic police car in that side door, correct?
There's an antique vehicle there, yes, yes.
If you take a close look at the trunk of that vehicle, see the word police,
Yes, I believe I can read that, yes.
and it's backward, correct?
It is mirrored, correct.
That's a good indication that this is an inverted video, right?
Not necessarily, since some emergency vehicles, and I actually thought that was the front of the classic police vehicle. On the fronts of emergency vehicles, they do have the lettering backwards so that in your rear view mirror, it shows up forward. So, you know, but we've already established that it's mirrored, so this is just cumulative.
Appears that way, yes.
If we were to fast forward at 5:42,
Okay, it is the rear. Never mind.
another 20 seconds. There you go. Can you just play at this point? Oh, you take one pause. Pause it. You see the Southport garage came down?
Yes,
You see a number on the garage? Is
I do.
that correct?
What is correct?
There's a number here, correct? How do you make it four?
No, the number's in the mirror image, yes.
I just wanted
This
to
is
make a point.
cumulative.
Everything in this video.
This is
correct?
cumulative.
It's not backwards, it's mirrored, reversed.
It's
You can look yourself in the mirror
cumulative.
in the morning, you still see your own face. It's
Objection.
not backwards.
Cumulative.
But my mirror image is not an accurate depiction of who I am. My actual physical appearance is who I am. Correct?
Argumentative.
A mirror image, Sergeant, is not an accurate video.
Argumentative.
It's a mirror image by definition.
Stop.
Sustained. Ask it differently, Mr.
Stop.
Jackson.
Your Honor, thank you.
When he says objection, you stop. You don't charge over him. Stop.
I would like to mark. I have a, we can bring the mics up.
Wait.
I have a thumb drive that I'd like to have marked with court permission.
Does Mr. Lally know what's on this thumb drive without you telling us?
The thing about the mirroring is Lolly should have pointed it out. And then that should have been the end of it. Because the reality is, if it's the way the security camera is set up, it's the way the security camera is set up. If it's the way it records, it's the way it records. Whoop-de-doo. The thing is, I would present it as it's recorded. I wouldn't flip it, because then it's doctored and you're going to get objections. You doctored this. It was recorded in mirror. Da, 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 da. But you need to point it out. You need to point it out. But Jackson pointed that out 15 minutes ago. All of this has been cumulative.
I do not.
Okay.
We can approach that and certainly bring it up.
We're trying to wrap up our morning.
Yes,
It's marked for identification.
if I may, Your Honor. I'd like to play the first 10 seconds of that video.
No. We'll come to second. It's marked for identification, right, Mr. Jackson?
You are
And I think I mentioned the taillight, but in the testimony, they didn't actually mention the taillight, I don't think, from that video. So you are correct. Let's see. Okay, I think we're done for the day, but let's go to here. I think we're done for the day, which is good because I can actually eat dinner today, except I need to run to the pharmacy, so I need to get there before it closes. But while I'm there, I can get dinner. No ramen for Joe today. And so, and the thing is, he could, I'd still want it presented as it's collected. But once again, why is it collected that way? But the truth of the matter is, Lolly should have pointed it out. And if he hadn't noticed, he should have noticed.
Okay, so we'll just wait. Jurors, I know that you want to know when this case is going to end, and I don't mean that in any negative way. After speaking with the lawyers, I can safely say that you will get this case for your deliberations sometime the last week in June. We'll know better next week. We will not be in session next Tuesday. We will go full days, Monday, Wednesday, Thursday, Friday next week. We will not be in session next Tuesday. I have to give you those cautions again. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Great weekend. We'll see you later.
All right, so the jury, please, jury.
you are muted.
All right, let's take a peek at what Karen's actions are here. She doesn't look happy. She actually doesn't look happy. No smiling and eye rolling and yucking it up. She doesn't look happy today.
All right, so I received a motion from the Commonwealth this morning that I have not had an opportunity to read yet. It's on my desk. I'd like to go spend a few minutes looking at that and come back out at 12 o'clock on that.
In order for us to argue it?
Yes. Do you need?
I don't get it.
Okay. All right.
Could we do it on Monday?
I want to get as much evidence in as we can each day. We can do it at 8:30 Monday morning, I think.
Okay. So motions I don't need. My understanding is it's the Commonwealth seeking to exclude one of the witnesses. I think an expert witness of the defense for failure to disclose in a timely manner. You know, what's good for the goose is good for the gander. Both sides have to follow the rules. If the Commonwealth has to get things in on time, so does the defense. So Karen didn't look happy. You know, normally she's yucking it up as the jury's walking out. She looked annoyed. And it wasn't the resting bitch face annoyed. She looked annoyed. So, yeah, it's, of course, as we've discussed, body language analysis is a pseudoscience at the best of times. In a trial, it's especially bad since, you know, you're coached. You're trying to look a certain way. You're trying not to react in certain ways. So, you know, the most telling part is when the jury's out of the room. But, yeah. So, I really dislike Alan Jackson. Still. I really dislike David Iannetti as well, but Alan Jackson, ugh. Ugh. So, yeah, we, as the judge said, we have no court tomorrow, no court Tuesday, but full days every other day next week, which, I might do it at 1 3/4 speed again. Just those 8.5 hour streams are murder. No pun intended. I might see you tomorrow because, as Paul pointed out a little while ago, we have updates in Schofield versus Guillard, the TikTok psychic case. And I'm behind on that anyway, but big update. So there's a possibility I might do it tomorrow or Sunday, depending on how things look. Or I might be a completely lazy asshole and do, you know, have a 3-day weekend because I deserve it after yesterday. So either way, as I mentioned, I do need to get to the pharmacy before it closes. And yeah. So all that said, do the YouTubey things, like, share, subscribe, and I will, at the very least, she will be. At the very least, I will see you on Monday. So have a good weekend if I don't see you until Monday. Bye-bye.